Let me.
Yes. Yes. What did you say? Call on the list.
Appellate side mention.
10:30 কোনগুলো আছে? 10:30 ফিক্স থাকলে সেটা আগে ডাকবে, হ্যাঁ। তুমি মেনশনটা ডেকে না, তুমি মেনশনটা কেন দেখেন? তারপর 10:30।
Well, this matter was there before your lordship last week also.
Yes.
I told your lordship that as such we are not pressing the appeal, save and except an observation by this learned judge in the court below who had said that one related matter would be taken up first. Last time, since I didn't have the copy of the order, my lord could not dispose of the matter. Today I have the copy of the order.
What is
I
the-
was appearing along with Mr. Bose, my lord.
Yes.
What
The
did I tell
impugn
your
order here,
lordship?
Mr. Bose?
Well, I tell your lordship,
Just please remind us. Yes.
well, there was an application under section 397 and 398 of the Companies Act moved by Hungerford against Turner Morrison.
Yes.
The application was dismissed. Appeal preferred, appeal dismissed. Review preferred, review dismissed. So the chapter, my lord, attained a stage of finality. What happened thereafter was Hungerford started taking out a great many applications trying to revive, my lord, the disputes which had already been disposed of in CP 33
Yes.
and dismissed. So when that happened, since there were a whole lot of applications, we took out a formal application saying that since CP 33 stands finally disposed of, nothing in connection thereto can be taken out.
Yes.
In that connection, the learned single judge, my Lord Justice Aniruddha Bose, as his lordship then was pleased to hold that I had observed that I would hear out the application between being CA number 277 of 2015 first, as in that application, main contention of the applicant is that no further proceeding in the court can continue in connection with CP number 33 of 88.
So now what has happened by the impugn order?
By the impugned order, my lord, what has happened is he took out an application under section 340.
That was
That the learned single judge was merely pleased to observe that I would also be heard. Strictly speaking, I need not press that appeal. But
yes.
I was just wanting, if it commends to my lord,
You could
an
have pointed
observation.
this out to the learned single judge also that this order is there.
If your lordship's observation would
And
help.
340, Mr. Bose, is on a different footing, somewhat different footing.
But I just want to say, my lord, since it is all in connection with CP 33.
So suppose your CP, the CA 277 is allowed also, then also 340 is on a separate footing. It can be taken up.
No.
340 criminal procedure code.
Yes. So all that I'm saying is an
So
observation.
that is not purged. If there is a perjury, that is
No. That is pending.
that has to be taken up in it.
That has to be given a hearing. All that I'm saying is I will go back for a hearing before the learned single judge.
Yes.
If an observation could be passed that in view of this order, let CA 277, my lord, be taken up first before the appeal, or let this instant appeal, my lord, be taken up along with the cluster of matters which will be heard after 277 of 2015.
Yes, what do you say to them?
But I appear for the cross object in item number 2. But it's also my appeal.
They are not
But
appearing
I'm
anymore.
standing here because this side seemed to be empty. That's why.
No, the appellant is not here before us.
I am the appellant.
In this matter, oh right.
Yes.
And item 2, I am the appellant.
No, the respondent who is the other side.
My lord, nobody is appearing for a long time after Mr. Hoon expired, my lord. These matters, we tried
Learned
serving.
senior, we are passing that order. Learned senior counsel appearing for the appellant submits that the only perceived grievance of the appellant is that the learned single judge, by the impugned order, directed that an application under section 340 of the Code of Criminal Procedure would be taken up along with CA 277 of 2015, the latter having been filed by the present appellant, contending that no further proceeding in CP number 33 of 1988 could have been proceeded with in view of an previous application under section 397 of the Companies Act 1956 having already attained finality, since the same issues could not be re-agitated. For the next para, we find from an order dated
18th June.
Yes, June 18, 2015, passed by the learned single judge, whereby it was observed that in view of the nature of CA number 277 of 2015, the said application was to be heard out first before the other applications. For sub next para, learned senior counsel contends that the limited prayer of the appellant is that CA 277 of 2015 should be heard in adherence to the order dated June 18, 2015. For the next para, we are of the opinion that an application under section 340 of the Code of Criminal Procedure operates on different footing than the main application bearing CP number 33 of 1988. However, there is substance in the contention of learned senior counsel for the appellant that since the said application bearing CA 277 of 2015 hits at the root of the main matter, the same ought to be taken up first. However, there is no bar in the application under section 340 of the Code of Criminal Procedure being taken up thereafter. Accordingly, in view of the limited prayer made by the appellant, APO, what is the OCOT?
OCOT is my cross objection in item number 2.
So what is that? You have challenged what?
That is from the same order.
You ask for the make the same prayer.
Same
Yes.
prayer. I
Very
also
well.
have this order.
In such view of the matter, APO 283 of 2017, along with OCOT 1 of 2018, is disposed of by without interfering with the impugned order, but clarifying that the portion of the impugned order whereby the two applications have been directed to be listed together would be read, would be construed to mean that CA 277 of 2015 shall be taken up first, and thereafter the application under section 340 of the Code of Criminal Procedure shall be taken up by the learned single judge. First up, there will be no rest to cost. Urgency certificate.
Very
Lordship, Lordship, I was appealing with Mr. Bose, my lord.
Yes, Mr. Sharma. Just ask somebody to give your name or put it on the inbox. In the inbox. Peter taken up. Peter taken up.
Lordship, item number 3, I am for the appellant, my lord. Mr.
Why is
Sen
it
is
appearing
there.
as to be mentioned?
Well, we mentioned because on the last occasion, we pointed out that now, my lord, the deed is there to be registered. If your lordship sees the first order, your lordship will get an idea, my lord.
There are two issues.
Well,
Number
may I
one,
just point out, my lord, first May 20.
my learned senior.
Yes, my lord, your lordship says 16th April 2024 order. If it is where the, my lord, the Honorable Division Bench, after hearing the parties, my lord, observed that the only thing which was remaining in the execution proceeding was the deed of family's arrangement, which was there to be registered. So my lord, the order, may I hand over a copy of the order? 16th May,
It just will find out to you.
16th April. Arekta dao.
Yeah, better hand up.
Finally, similar, pursuant to the award, a deed of family arrangement was executed by the parties, but they were not ad idem at the time of registration thereof, which led the execution proceeding to be levied. And this appeal is from that execution proceeding order. A further development took place in the meantime because of untimely death of the mother of the parties, for which direction was passed in the execution.
This family arrangement was entered into after the award, at the execution stage.
No, not after the award, the parties entered into a family
Execution is of the
arrangement,
family arrangement.
and execution was of the family arrangement.
So now what about
Now, my lord,
registration was the hitch? It was
registration was only on
we
the.
used to pay the fees. Registration.
No, my lord,
Yes.
what is the stamp duty which is leviable? Now, my lord, that
That's
was
an
since
understanding.
we were at variance.
Well-
Mr. D.N. Mitra was appointed to look into this issue and to present the deed for registration. Now, my lord, whatever deed he has lastly forwarded to us, we are, at least my client is now ad idem. My
What
client,
about the stamping and registration?
we are now
I may take
agreeable,
1 minute.
whatever he has done. Now, only thing which remains is to be registered.
So we can direct the deed to be
That's
registered.
not be 1 minute only.
Mr. Banerjee is appearing.
Yeah, I'm being led by.
My lord,
I'm being led by.
good fortune of my lord leading Mr. Sen, my lord, today. But I'm sorry, my lord, I'm not there, my lord.
No difficulty,
Physically,
Mr.
I'm very
Banerjee.
sorry.
So,
my
so
lord.
we have got your
My lord,
version.
Yes,
Now,
my lord, just
my
one
lord,
statement, my lord, one
lordship take-
statement, my lord, with Mr. Mukherjee, just one. I'm so sorry, my lord, just one statement. My lord, the entire deed has to be registered. That's my lord our contention with regard to annexure schedule 4 as well, which my lord is, I think, my lord, quite reasonable because that's the entire deed, my lord, which has been, my lord,
It's part of the deed.
So that would dispose of this EC
The
itself.
entire appeal. And
Appeal itself.
yes, the execution will stand. It will now stand executed.
Well, yes.
My lord will take the 12th November order. Firstly, my lord, it's all over written, my lord, that on two portions it's written, it's in principle, the terms of settlement. That should be the family arrangement.
Yes.
Now, what has
Yes.
happened, my lord? Well, this execution of the family arrangement is with regard to Schedule 2 and Schedule 3 properties. The judgment debtor, that is Sunil Swaika, has gone and filed a suit for partition where, my lord, Schedule 1, Schedule 2, 3, which is for subject matter of this execution, and Schedule 4 properties are made subject matter. In that suit, my lord, an order of injunction has been passed. Well, this is the order which has been passed.
That is dealing with the
My lord,
property.
I'll come to it, my lord. If your lordship just takes that order, my lord.
And we have applied for vacating of
Exactly.
this also.
That order has to be modified. That matter is coming up, my lord,
Why it has to
on
be modified?
15th of December.
Mr. Sen, unless that order
That
is
order has to be modified.
modified, it can.
That is
Because
the
there's a
problem.
clear
Yes.
bar. There's an
It
injunction.
is our
if
contention,
your
my lord,
lordship-
that Schedule 2 and 3 properties
But-
can't form part of that partition suit at all.
If it's registered, that is the title
That's
will
the
pass.
problem.
Then.
But may your lordship will kindly
Your
have a look at the order.
My request is,
Keep
my
it-
lord, if
we'll
your
keep it
lordship
after
keeps
15th.
after 15th of December.
But
Yes,
may I only submit this
We'll
one?
keep it on 17th of December.
17th
No,
of
that is
December.
okay. My lord. Only thing is that,
Yes.
yes, Mr. Banerjee.
Mr. Banerjee,
Yes.
we'll keep it on
my
17th.
lord, very well, my lord. I don't think, my lord, the order should affect, but my lord is correct, my lord. We should,
should
my
not
lord,
be any,
also, my lord,
problem
because
there.
it's
No,
just
no,
because
both of you are
because the
agreeing.
We are
Yes.
saying we want
Yes.
to withdraw the partition suit because there are some
You
defects.
do that on 15th of December then.
Yes, my lord.
The short point involved in the matter now is regarding registration of a deed of family arrangement entered into by the parties after passing of the award. Full stop. Next para. Learned senior counsel appearing for the appellant submits that since the party
take your lordship's leave?
Yes. Since the parties are now add item as to the registration and the stamping of the document in question, comma, the execution case, the appeal itself may be disposed of by directing such registration to be done by the special officer appointed for such purpose. Push up next para. Learned counsel appearing for the respondent submits that there is no difficulty on the part of the respondent in acceding to the above proposal. Full stop. However, comma, since a partition suit is pending, where an injunction order has been passed restraining the plaintiff therein, that is the present appellant, from transferring, selling, alienating, encumbering, or otherwise dealing with the suit property, comma, the same is required to be vacated, stroke modified for the purpose of going ahead with the registration of the family arrangement. Which of next pair, it is also submitted that the said matter is fixed on December 15, 2025. Push up, since the parties are ad idem on the registration of the deed of arrangement and assure the court that they'll all take all steps for vacating stroke modification of the injunction order and stroke or the appellant withdrawing the partition suit itself,
No, no,
comma,
with withdrawal, we are opposing the withdrawal of that suit because the other two properties.
and
Withdrawal, your lordship, they have also not filed a modification application as yet.
No,
So if we are
it's-
recording the modification, then
no,
It's all, we will
withdrawal-
take the step, we'll take steps.
take anything, state anything, because you are not ad idem on that. We are
The
holding
withdrawal,
it
we are
here.
not adding.
Very well.
Vacating or modification of the injunction order.
Comma, the judicial propriety demands that this matter be taken up on December 17, 2025, when it will be listed under the same heading, comma, to await the outcome of the proceeding before the learned single judge in the partition suit on December 15, 2025.
I'm grateful, my lord.
So this will appear on 17th of December under same heading, to image. Thank you.
Lord, the item number 4,
Yes,
if you
four.
can make not today, well, by consent, my lord. Item number 4.
ফোরটা একবার কল করে নিন, নট টু এটা করে দিন,
My lord, obliged to your lordship.
বোর্ডে দেখান, বোর্ডে দেখান।
This time praying for not today, my lord. With consent of my lord, net friend, my lord.
On consent of the parties, the matter is adjourned for the day.
Obliged to your lordship.
Next, 7-8. Yes.
7.
Ugly. এটা আমাদের কাছে পাঠালেন, তাহলে এটা তো ওই লিস্টে দিলেন না কেন যখন পাঠাট ক্যান্সেল করলাম? তাহলে পাঠাট ক্যান্সেল হয়ে গেছে, তাহলে পাঠাট হিসেবে দেখাচ্ছে কেন? তাহলে হয় নাকি এই বেঞ্চে কোনো পাঠাট হিসেবে দেখায় বোকা?
My lord, I presume,
Mr.
my lord, we
President.
start at the very beginning. My lord.
Just give us the rudiments.
Yes, my lord, my
That
lord,
would do.
I'll unfortunately, my lord, I'll have to go through, my lord, portions of the judgment, my lord, where,
Notes গুলো দাও.
my lord,
Just tell us the facts of the case.
Yes,
Mr.
ma'am.
President, that would.
yes. Now, my lord, the challenge, my lord, is, my lord, to an award dated 29th February 2020. Now, my lord, this was, my lord, challenged by way of two Section 34 petitions, in which, my lord, two applications were made under Section 36 of the Arbitration and Conciliation Act. My lord, in effect, other than, my lord, a purchase of shares, which was, my lord, an agreed part of the award, my lord, there was also a portion, my lord, with regard to, my lord, damages. So primarily, my lord, it was, my lord, transfer of shares for consideration and, my lord, a money award. So, my lord, there was, if a stay had to be applied for, my lord, the, my lord, deposit or security, my lord, had to be furnished. So there were two Section 36 applications. And, my lord, the prayer there, my lord, was to exempt, my lord, from, my lord, putting in any security on the ground, my lord, that the award was obtained, my lord, by fraud. Now, my lord, while that matter was pending, my lord, Section 34 had also been filed, and, my lord, there was an order already to the effect that 34 would be heard. Then, my lord, it was pointed out that in the 34 as well, my lord, this particular point had been taken. So, my lord, there was an order passed, which I need to draw your lordship's kind attention to. My lord, is, my lord, two orders. My lord, 13th. No. My lord, the first order is, my lord, volume 12, 1566. This is, my lord, an order of 7th of February. I'm sorry.
What are you suggesting? What I was proposing, we argue the whole thing.
Yeah, that's right. That's not part of it.
Schedule either 7
Yes. Volume to
Yes, my lord. This was, my lord, 7th of February 2023. My lord, page 1566, my lord, volume 12.
What other volumes should
My
we
lord,
go
12 and 13, my lord,
12
for
and
the
13,
time being,
for the
my lord,
time being.
12 and 13. My lord, I'll go through quickly, my lord, but I think, my lord, since it's starting
That's
afresh
better.
and considering what kind of a matter this is, my lord, your
Approach my
lordship.
learned brother with
Yes, my lord. So, my lord, it's best not to, my lord,
Then-
have, my lord, any, my lord, ambiguity in this, because your lordships also passed an order,
Yes.
my lord, in this matter, which your lordships would recall, my lord, 13th of August, 2025. My lord, I have copies of that also.
12 or 13 দুটো ভালো লাগে।
13th August, my lord, I have them here. আপনার ফাইলে এগুলো থাকা উচিত সব। You know that, no?
আচ্ছা ওটা দিয়ে দাও, দিয়েছি। লাগাতে পারো।
Overruling or objection.
Yeah, yeah.
Yes.
Yeah.
ওটা লাগাতে পারবেন এটা না? যদি পয়েন্ট করতে কিছু করতে। Yes.
My lord, kindly see, my lord. And I hope, my lord, that this still, my lord, applies. Because, my lord, it's a new bench. And, my lord,
But this time both of you have to be more precise so that this bench also does not have to cancel.
no, I'm clear, my lord. Your lord, my lord, all that I'm
That
saying.
applies to both of you.
Yes.
Him also.
Yeah.
There is no objection on our part this time. So, your lordship may continue with the hearing. Last time this order came to be passed because we had raised an objection.
Oh, no, that we are not reopening that chapter.
No.
Not that. We are asking, requesting both of you to be very precise so that
Precise,
this
yes.
bench also does not have to.
Just to be clear for my own sake, my lords, we are going to be arguing in that sense afresh, but although in a more precise manner.
Precisely.
Yes.
Yes, Mr. Mukherjee.
Yes, my lord. So, my lord, this was, my lord, the order, my lord, passed. So, I'll be now, my lord, go through very quickly. My lord, now the order which I was showing your lordships, my lord, is, my lord, of 7th of February 2023, my lord, where, my lord, the matter, my lord, was directed, my lord, the main 34, my lord, to be, my lord, heard. Then, my lord, subsequent to this, kindly come to, my lord, volume, my lord, 14, page, my lord, 1729. Oh, sorry, I didn't mention that, my lord.
No difficulty.
12, 13, and 14.
Yes,
12,
yes.
13.
13, 14 টা দিয়ে রাখো। করাগুলো জেনারেলি আমার হয়। এই যে ওয়ানটা ফার্স্ট জাজের লিখে দাও। 14, yes.
Now, my lord, this was the order which was passed. This court has indicated to counsel that the preliminary question of the end of mandate of the learned
This is
arbitrator,
page, sorry, Mr.
page 1729, my lord.
Yes, that order.
That preliminary question of the end of mandate of the learned arbitrator for having appeared for an alleged sister concern of the award holder during the pendency of the proceedings, as argued in aid of the application under 36, is also a preliminary issue in application under section 34. Substantial arguments advanced by Mr. Kohli and Mr. Ghosh in reply. The preliminary question in the application under 34 shall be heard along with the application under 36. 36 was confined to non-furnishing of security on the ground of fraud. Then these matters stand fixed on so-and-so. It expect counsel would conclude arguments as indicated. So-and-so's. Then, my lord, this is important. The applicant, namely Gopal Das Bagri, has filed 77 volumes of records of the arbitration, physical copies, etc., rejoinder to the application. Now, just kindly make a note of that because, my lord, this will have some relevance. Because, my lord, in the 34 and the 36, my lord, grounds have been given, my lord, as to why, my lord, the learned arbitrator was disqualified. And, my lord, several papers, my lord, from, my lord, which had now been referred to, and, my lord, I'm sure my learned friend will do it. My lord, my lord, have a caveat to that. My lord, that in the grounds, in the pleadings, my lord, there has to be a reference to that. My lord, with regard to, my lord, the grounds for disqualification, that what is being relied on, my lord, is for the purposes of, my lord, disqualification. My lord, I'm putting that caveat, and I told your lordships, my lord, on the last occasion as well. If my learned friend goes on relying on it, I'll deal with those as well. But I'm not going to deal with it, my lord, upfront. I'm going to deal with the case made out and, my lord, the judgment, my lord, as my lord delivered. Now, my lord, kindly come to. Now, my lord, I'll tell your lordship what happens. The ground taken for disqualification of the learned arbitrator is that while a disclosure was made, my lord, under section 12 by the learned arbitrator, when, my lord, he was appointed, my lord, by court and the parties appeared before him. And, my lord, I'll show that, my lord, what was the disclosure. Then what happens is, while the arbitral proceedings, my lord, are pending, my lord, according to, my lord, the respondents, the learned arbitrator, my lord, disqualified himself by appearing on behalf of a party who they say, my lord, is really, my lord, the alter ego, my lord, of, my lord, the appellant number 2, right? Appellant number 2 before your lordships. And this fact had not been disclosed when during the course of the arbitral proceedings, and therefore it automatically ended the mandate of the learned arbitrator because there was no disclosure, and that's the short ground on which the award should be set aside. In short, that is, my lord, the matter. Now, my lord, kindly come to the impugned order, my lord.
Arbitration Conciliation Act দুজন পেরিয়ে Yes.
You have Arbitration Conciliation Act. Now, my lord, kindly take the impugned order. It's volume 2, page 1570.
Volume 2.
Volume 12, sorry, my lord. Volume 12,
12 আছে।
1570. My lord, I just want to show, my lord, lordships have a copy of the arbitration. I have copies. So, my lord, you have the latest acts. Do you have? You have another?
Yes, yes, we had copies. দেখো দেখো
আমার তো
তোমাকে দিয়ে দেওয়া হবে? Yes, we have copies. 157.
Yes. Now, my lord, kindly come to paragraph 12. My lord, at page 1572.
Yes.
In the first sitting of the arbitration held on 10th August, the learned arbitrator disclosed in writing to the parties that he had earlier represented Bulaki Das Bhaiya and his group companies. Kindly mark this, my lord, and his group companies, who is evidently a claimant in the proceedings. Upon such disclosure, the award debtors indicated to the arbitral tribunal that they had full faith and confidence in the learned arbitrator. The relevant portions of the minutes of the meeting held on 10th August are set out below. At the outset, the arbitrator informed the parties that he had professionally been engaged several years ago as counsel to appear for Mr. Bulaki Das Bhaiya, one of the claimants in the proceedings, or by companies within his management and control in certain earlier legal proceedings with regard to which Sri Bhaiya had attended the conferences and had occasion to come confer with and meet the arbitrator. The arbitrator further informed the parties that his son, Mr. Ravi Kapoor, advocate, had apparently also appeared for the claimants in interlocutory proceedings arising out of so-and-so. Mr. Jishnu Shah, appearing for the respondent numbers 1 to 5, and Ms. Shulogna Mukherjee, advocate, appearing for 6, 7, and 8, informed the arbitrator that they had been apprised of details of the foregoing circumstances and, being fully aware of the same, had proposed the name of the arbitrator before the Honorable High Court to act as arbitrator in this proceeding. Counsel also stated that they had full confidence and no doubts about the independence and impartiality of the arbitrator and requested him to enter upon reference and continue with the arbitral proceedings. Now, my lord, just pause here for a moment. My lord, the appointment, my lord, was in the suit. My lord, where, my lord, because of, my lord, the proposal made by the other side, my lord, that suit was arrested, and, my lord, I lost the assistance, my lord, of my learned junior. It was, my lord, the proposal came from them, and, my lord, knowing, my lord, that, my lord, the learned arbitrator, my lord, had appeared, my lord, for one of the claimants. In spite of that, my lord, the proposal is made. And, my lord, full confidence. Arbitrator thereupon commenced the arbitral proceedings. Now, my lord, kindly come to My lord, para 13. This gives, my lord, the background leading up to, my lord, so I'll just, the factual, as many as 126 sittings were held in the arbitration between 10th August 2014 and 9th of December 2017. After a year-long hiatus, on 3rd of January 2019, the arbitrator declared that a draft of the award was ready, and after corrections and proofreading, the final award would be ready soon. The minutes of the meeting dated 3rd January 2019 are as follows. Now, my lord, I just want to indicate, pausing here, my lord, 112th meeting, my lord, of, my lord, the arbitral tribunal, my lord, had been, my lord, held, my lord, on 18th of November 2017. My lord, after which, my lord, there had been a hiatus, as has been pointed out. After a long hiatus, on the 3rd of January 2019, the arbitrator declared that a draft of the award was ready, and after corrections and proofreading, the final award would be ready soon. Minutes of 3rd January 2019 are as follows. The arbitrator apprised the party that his draft of the award was ready, and it would take a few days to do the proofreading of the same, as well as making necessary correction of typographical mistakes, and he expected the final copy to be ready very soon. The arbitrator directed both the parties to deposit 2 lakhs each with him by Monday, 7 January, to meet the secretarial expenses, etc., in respect of preparation. Between 5th of June, then, my lord, to 19 July 2018, the learned arbitrator, kindly mark this, my lord, in his capacity as a senior advocate of this court, appeared in the High Court in so-and-so, arising out of so-and-so, Standard Shoe Sole and Mold India Limited, SSSMIL, versus SM Chemicals before division benches of this court as lead counsel for the said SSML on 11 occasions. It is stated on affidavit that Bulaki Das Bhaiya attended meetings and conferences with the learned arbitrator in connection with the aforesaid APD 252 of 2015 held with the learned arbitrator. Admittedly, SSSMIL was formerly known as Chemcrown India Private Limited. SSSMIL is a company owned, controlled, and managed by one BG Chemicals Private Limited with an ownership of 25.68% shares. BG Chemicals Private Limited itself is owned, controlled, and managed by Bulaki Das Bhaiya and his family members. Registered office of SSSMIL is the same as that of award holder CNE, so-and-so. Shareholding pattern of BG Chemicals is as follows. Now, my lord, the particulars are given of BG Chemicals. My lord, Bulaki Das Bhaiya 80, Gauri Shankar Baldeva 20, Ganga Devi Bhaiya 8,000, Bulaki Das Bhaiya HUF so-and-so 10,000, and my lord, total shareholding A plus B equal to 10,000 equity shares of so-and-so. On 23rd February 2019, the learned arbitrator directed the parties to make submissions afresh, despite having already indicated on 3rd January 2019 that the award had been finalized. Minutes of the meeting of 23rd February 2019 recorded as follows. Before dealing with other matters, I find from Mr. Singhvi's letter of February 19, 2019 that he has referred to the issue of delay. Undoubtedly, there has been delay. That was us making a complaint. The expectation of counsel was that the matter would be concluded in a 6 months' time when they took the order of reference from the Honorable Court. Regrettably, within 6 months' time, parties did not complete additional pleadings. After that, the arbitrator, without intending offense to anybody, was compelled to give due regard to the overburdened professional times of counsel. However, that may have been, the hearings intermittently, accommodating everybody, continued until mid-2017, when I told both sides that they must proceed on a day-to-day basis and conclude the hearing. I was assured that notes would be given. Before arguments were made. Regrettably, this was not done. One set of notes was received by the respondents around June or perhaps July, and then counsel argued for the respondents on the first claim with regard to price of goods sold and delivered. After that, counsel for the claimant took over and presented his arguments. I did not then get any notes from anybody. This continued till 3rd December 2017, when I closed the arguments and asked counsel to give me their notes. One set of notes was received in January 2018. Second came from the other side in February 2018. And the last set came from the claimants in May 2018, which was just on the eve of the summer vacation. I was then proceeding abroad and then took up the matter for consideration after the vacation. By then, I must honestly admit that very little of the case, if anything at all, remained within my immediate recollection. I was compelled to read the entire bundle of papers by myself and put together my own determination with regard to over 20 separate issues. I had prepared a draft award in December 2018, and before finalization, it took some time when unfortunately the matter because of my commitments went out of my mind again. By my notice of 18 February, I asked the parties to come to address me on certain matters, which I think they had left incomplete in their earlier arguments. Hence the meeting. As many as 13 more sittings were held from 23rd February to 9 September 2019. Award was made 6 months thereafter on 29 February 2020. A brief chart or sequence of events and dates in the arbitration and relevant intervening actions is set out herein below. Now, my lord, kindly come straight away to, my lord, the second entry, 13 September 2014 to 9 December 126. Then, my lord, there's a hiatus for the whole year of, my lord, 2018. 3rd January, my lord, onwards, my lord, is narrated above right up to 29 February 2022. Then, my lord, para 90. The arbitrator admittedly did not disclose or inform the parties that he had appeared several times in the High Court for SSSMIL during the aforesaid hiatus period. The award was declared in favor of the Bhaya Group and its associates for an overall sum of 22 crores together with interest. Operative part of the award is as follows. Now, my lord, this is, my lord, set out. I don't think I need to trouble your lordships with this. Then, my lord, this is, my lord, the, my lord, facts. With, on the basis of which, my lord, the matter, my lord, has, my lord, proceeded. Now, my lord, kindly come to para 48.
Yes.
My lord, which is, my lord, at page 1587. Yeah, I have them. Now, my lord, the first. Now, my lord, before I come to this, my lord, I must show your lordships, my lord, the act, my lord. My lord, kindly have a look. My lord, at section, my lord, 12, my lord, of the act. My lord, I hope your lordships have an act which gives the previous
Yes.
position as well.
2015.
Yes, my lord. That should be as a footnote, my lord.
Yes.
Yes. Now, my lord, I'm on the footnote first.
Yes.
My lord, kindly see 12.1. My lord, at that point of time, read, my lord, when a person is approached in connection with his possible appointment as an arbitrator, he shall disclose in writing any circumstances likely to give rise to justifiable doubts as to his independence or impartiality. Now, my lord, this is, my lord, a position, my lord, prior to appointment. But the appointment had already happened with, my lord, full knowledge of the respondents here. My lord, that, my lord, the arbitrator, my lord, had, my lord, appeared, my lord, for one of the claimants. And, my lord, whatever, my lord, people understood as group companies, where, my lord, advice had been given, my lord, in the presence of, my lord, the claimant number 2, who attended, my lord, conferences. Now, my lord, the old, my lord, subsection 2, my lord, remains.
Yes.
My lord, kindly see that an arbitrator from time to time of his appointment and throughout, etc., shall without delay. Now, there were 2 explanations, along with an amendment, my lord, of, my lord, 1A, my lord, which were, my lord, added by the amendment, my lord, of 2015, operating, my lord, from 23rd October 2015. Now, one, my lord, changes. Kindly have a look. When a person is approached in connection with his possible appointment as an arbitrator, he shall disclose in writing any circumstances, A, such as the existence, either direct or indirect, of any past or present relationship with or interest in any of the parties, or in relation to the subject matter in dispute, whether financial, business, professional, or other kind, which is likely to give rise to justifiable doubts as to his independence or impartiality. B, we are not concerned with, that is, my lord.
This entire subsection 1 is at the time of approach.
Correct.
So that was already over when 2015 came.
Yes, my lord. In fact, approach was not, my lord, nobody approached the arbitrator.
No, but
It was a
whatever-
court order, my lord, he thought fit to
2015
make.
amendment came after the commencement of the
Correct, correct. And this amendment came after.
Yes.
Now, my lord, kindly come to explanation 1. The ground stated, my lord, this is what was added. My lord, 1B, my lord, is not relevant. That relates to how much time can be given. My lord, I'm not. Then explanation 1. The ground stated in the 5th schedule, now kindly mark this, shall guide in determining. This is a statutory provision, shall guide in determining whether circumstances exist which give rise to justifiable doubts as to the independence or impartiality of an arbitrator. And then, my lord, form in which disclosure has to be made. Now, kindly come to subsection 2. My lord, this is also important. An arbitrator, from the time of his appointment and throughout the arbitral proceedings, shall without delay disclose to the parties in writing any circumstances referred to in subsection 1, unless they have already been informed of them by him.
So this
So continuing of
yeah, yes, then lends relevant to the amended one also.
correct.
Because
My lord,
during the-
amended 1, and for amended 1, my lord, the guiding factor is, my lord, explanation 1.
Yes. Yes.
My lord, this is, my lord, how, my lord. Then, my lord, subsection 5 may not be wholly relevant at present, notwithstanding any prior agreement to the contrary. Any person whose relationship with the parties or counsel or the subject matter of the dispute falls under any of the categories specified in the 7th schedule shall be ineligible to be appointed as an arbitrator, provided that parties may, subsequent to disputes having arisen between them, waive the applicability of this subsection by an express agreement in writing.
This also relates to the appointment of an arbitrator
Correct.
at the time.
Correct. Now, my lord, kindly have a look at the.
Two links, the amended one also during
Correct,
continuance.
correct.
But there is nothing of
No, that's not there.
5.
And my lord, they're almost identical, the schedules.
Yes,
So, my
schedules are
lord,
mostly identical,
yes,
barring a few.
yes. Now, my lord, I'll just place, my lord, schedule 5, my lord, the 5th schedule.
Yes.
My lord, kindly see. They make a reference, my lord, it should be, my lord, 12.1a, but they write 12.1b. Now, my lord, the following grounds give rise to justifiable doubts as to the independence or impartiality of arbitrators. Now, my lord, first category is cases is arbitrators' relationship with parties or counsel. This is, my lord, 1. Then, my lord, relationship, kindly take after 14. I'm just giving the broadheads now. Then relationship of the arbitrator to the dispute. Then, my lord, arbitrators' direct or indirect interest in the dispute. Then, my lord, previous services of one of the parties or other involvement in the case. Then, my lord, relationship between an arbitrator and another arbitrator or counsel. And, my lord, other circumstances. Now, my lord, kindly come to, my lord, explanation 2, which is, my lord, very important. The term affiliate encompasses all companies in one group of companies, including the parent company. So, my lord, there has to be, my lord, a parent company. That was my submission. My lord, when we are looking at group of companies, and that is, my lord, the law as well, which I shall, my lord, refer to. In a group of companies, my lord, there has to be, my lord, a, my lord, parent company. Now I come back to, my lord, paragraph 48. My lord, at page 1587.
Yes.
The question put, my lord, and my lord, my respectful submission, my lord, would be, my lord, that this is possibly, my lord, not the correct question to have been put or answered. I'll tell your lordships why, my lord. Kindly see, is SSMIL an affiliate of the Bhaya group? Having heard counsel for the parties, this court finds that the Bagri group has not seriously disputed the shareholding of Bulakidas Bhaiya and his family members in BG Chemicals Private Limited. I believe this should read as Bhaiya Group, my lord, not Bagri. Am I right? My lord, I would, my lord, otherwise, my lord, it's totally.
We were thinking that.
Yeah. It has to be, my lord, kindly take it as Bhaiya Group. And his family members in so and so, which has a controlling interest. Now, kindly mark this word, my lord, controlling interest in SSMIL, except to say that members of the Bagri family are also shareholders in SSMIL. The control of Bulakidas Bhaiya in SSMIL through BG Chemicals Private Limited could not be seriously disputed. Now, my lord, I pause here. So, my lord, we have, my lord, SSMIL, for whom the learned arbitrator appeared. In that company, my lord, we had, my lord, several shareholders, my lord, of which, my lord, BG Chemicals, my lord, held, my lord, approximately, my lord, it's the shareholding, I'll come to that later. My lord, had shares, and BG Chemicals was controlled by Bhaiya, and therefore, my lord, it was controlled, my lord, by, my lord, Bhaiya. This is, my lord, the position. On the contrary, at page 9 of the affidavit in opposition, there is an indirect assertion to that effect. My lord, I place this, my lord, the allegations, I'll come to this, my lord, when I deal with. So, my lord, this is the position. Now, my lord, straight away, my lord, I want to show your lordships. In fact, I should read it here so that, my lord, I can attack the next portion. The allegations made in paragraph 4 of the petition are denied and disputed. It is denied that the information given by the learned arbitrator to the parties, as is evident from the minutes of the first sitting of arbitration, in itself amounted to a representation that he would not appear for, represent or advise Bulakidas Bhaiya or any of his companies in the course of the arbitration. So, my lord, what they understand, my lord, by the disclosure made is first it's a representation. And, my lord, that what is the representation? That he would not, my lord, advise Bulakidas Bhaiya or any of his companies in the course of. So, my lord, a company which is Bulakidas Bhaiya or his company. It is denied that the petitioner so and so agreed to the learned arbitrator entering upon reference and continuing clearly with the understanding would not act as legal advisor any of group companies during pending. In this connection, it is stated that several sittings were held after July 2018 and the advocates appearing for the award debtors before the arbitrator were well aware of the fact that the learned senior arbitrator had appeared for SSMIL appeal in his professional capacity. In fact, the learned senior advocate had also appeared in other matters of SSMIL. As such, it was, though unnecessary to record the same at the time, since the learned arbitrator had already made the disclosure under 12 and the parties had consented to his appointment, no application was made challenging his qualification, independence or integrity, even though it continued up to February 2020. At every meeting, representatives of the applicants were present and no one raised any objection. Learned arbitrator so-and-so had been associated with the suit at all material times. The plaintiff in the suit, SSMIL, is not a party to the instant arbitration and there was no reason for the learned arbitrator to disclose proceedings, etc. Then, my lord, in fact, some of the respondents in the arbitration proceedings are also shareholders in so-and-so, that is Inder Kumar Bagri, Gopal Das Bagri, and knew and all were deemed to have known about the appeal. It is unfortunate that the applicant is insinuating that the advocates appearing from the claimant in arbitral proceeding were also representing the appellants in so-and-so. As mentioned above, learned arbitrator so-and-so, so-and-so, and a particular learned senior advocate in numerous matters during pendency of the arbitration proceeding. In fact, I have been informed by the award holder number 2 that the learned arbitrator held several conferences with the aforementioned advocates of the applicant respondent during continuance of arbitration proceeding. Moreover, so-and-so has also appeared in other matters, so-and-so and as such, insinuation made about advocates appearing is not appreciated. State allegations made are irrelevant in bad taste only because happens to be busy working with different advocates and render, etc. Because, my lord, this really came because what was said was Mr. Kapoor had also appeared with some advocates. So, my lord, pat comes the response that their advocate, my lord, was also, my lord, there, etc. I'm not. Then, my lord, now, my lord, come to para 49. From a conjoint reading of the extract from the affidavits as above, the declaration of the arbitrator in the first sitting, also extracted here and above, the shareholding pattern of BG Chemicals, its 27 odd percentage shareholding in SSMIL and the other shareholders of SSMIL, it could be inferred, kindly mark this, it could be inferred that Bulaki Das Bhaiya has overall control and management of SSMIL and CNE Limited. It can also be inferred that the managers, directors, and employees are accustomed to acting as per the sole wish and dictate of Bulaki Das Bhaiya. Now, my lord, the arguments have been recorded. My lord, I'll show from the affidavits also. And the extracted portion, my lord, which has been relied on. My lord, this does not fit in at all. Because, my lord, what is said is, now here, first thing that is said is, in SSMIL, BG Chemicals has about 27% shareholding. Now, my lord, simply on that basis, my lord, it is, my lord, kindly see what all, my lord, are being inferred. That, my lord, Bhaiya had overall control and management of, my lord, SSMIL and CNE. And it is also inferred that managers, directors, and employees are accustomed to acting as per the sole wish and dictate of Bulaki Das Bhaiya. My lord, there is, my lord, no basis, my lord, to, my lord, arrive, my lord, at, my lord, these inferences. My lord, it's a big step, my lord, which has been taken simply on the basis of, my lord, the shareholding of 26 odd percent. My lord, in, my lord, of BG Chemicals in SSMI. Then, my lord, now, my lord, it, my lord, gets worse. Kindly come to page, with the greatest of respect, my lord, to, my lord, the learned judge. Kindly come to para 50. In GA 1 of AP 364, at paragraph 3, it has been averred that Bulaki Das Bhaiya had founded ChemCrown India Private Limited. Now, kindly mark the words here, private. Because ChemCrown, my lord, becomes, my lord, a listed company, a public company, where, my lord, the, my lord, shareholding, my lord, of, my lord, BG is only, my lord, 26 odd percent. It's not, my lord, what the situation we are looking at is not as it was when incorporated as a private limited company, which is the former name of SSMIL. Mr. Bhaiya was personally present in most of the sittings in the arbitration. Now, my lord, it could therefore not be difficult to believe that he must have personally attended most of the conferences with the learned arbitrator at the time of briefing for appearances in connection with so-and-so between January and December. My lord, Bhaiya is personally a claimant, my lord, in the arbitration. He is attending the arbitration. From that, my lord, it is being inferred that because one of the companies, my lord, which held shares in SSMIL, and that too, my lord, 26 odd %, which, my lord, Bhaiya controlled, Bhaiya would have attended. First, that there were conferences. Second, my lord, that he would have attended, my lord, those conferences. Then, my lord, para 51. Family controlled companies are commonplace in India. The control of the family is exercised either through direct shareholding of the family members or through other companies controlled by the same family or a member of the same. Then, my lord, the above proposition of law, above proposition is clear from the expression control and management as explained succinctly in the case of ArcelorMittal. So what is relied on, my lord, is, my lord, ArcelorMittal to, my lord, give this, my lord, to advance, my lord, this, my lord, proposition. And I'll, my lord, place that, my lord, immediately after this, my lord, paragraph. It's quoted, my lord, para 50 and 51. I'll, my lord, come back to that. Now kindly have a look at volume 13, my lord.
Yes.
Then, my lord, para 52. In the context of the Income Tax Act, the Supreme Court recently, in the case of Mansarovar Commercial, so and so, has stated as follows. The sum and substance of the above decisions of this court as well as various high courts would be that where the head and seat and directing power of the affairs of the company and the control and management must be shown is not merely theoretical control and power, that is not de jure control and power, but de facto control and power actually exercised, kindly mark the words, actually exercised in the course of the conduct and management of the affairs of the firm, that the domicile or the registration of the company is not at all relevant and determinate test in where the sole right to manage and control of the company lies. My lord, where would the incidence of taxation, my lord, be? Where, my lord, there's de facto control and management, or, my lord, we have, my lord, a company registered in Liechtenstein, my lord, which is doing, my lord, business in India. Should it be taxed in India, or, my lord, should it be taxed in Liechtenstein? This was, my lord, what was being. And the important thing is, it's a question of fact. Kindly see, my lord, control and management must be shown is not merely theoretical control and power, not de jure, but de facto control and power actually exercised. My lord, this was, my lord, the test. Now, my lord, 54. Given that the definition of an affiliate under section 12 of the Act encompasses all the companies, including the parent company, this court is hesitant, kindly mark this, is hesitant to hold that SSMIL is an affiliate of CNE Limited of the Bhaiya Group in the arbitration. One has to show a parent company, my lord, to come within a group. Then, my lord, Mr. Ghosh's argument that an individual, Bulakidas Bhaiya, in control and of so-and-so does not qualify as an affiliate cannot be accepted by this court. Now, my lord, this is directly contrary to, my lord, the previous sentence, and, my lord, directly contrary to the explanation, my lord, given to the schedule. Then, my lord, the said Bulakidas Bhaiya and his family members directly or indirectly do control and manage SSMIL and CNE, and the latter two companies function as per the wishes and dictates of Bulakidas Bhaiya. My lord, finding, my lord, without basis, my lord, there is, my lord, no factual fact which has, my lord, been relied on, my lord, to arrive at this finding, my lord, in the order. This court is therefore of the view, this court is therefore of the view that an individual or a group of persons, including a family in control and management of a company, upon lifting of its corporate veil, can definitely qualify as an affiliate within the meaning of explanation 2 to the 5th and 7th schedules read with section 12. Now, my lord, I pause here. My lord, first thing. My lord, control, my lord. The entire issue, my lord, of control is decided, my lord, on the basis of ArcelorMittal. That's number one. Second, my lord, having held that it's difficult to hold, that, my lord, CNE and SSMIL are affiliates of each other. My lord, the, my lord, learned judge goes a step forward and says, look, individuals can be an affiliate. For that, I just need to lift the corporate veil. Who, my lord, ultimately hold, my lord, on this basis, that, my lord, there was breach of, my lord, the 5th schedule and the 7th schedule. Now, my lord, I say here that the foundation, my lord, foundational findings, my lord, of, my lord, the learned single judge are, my lord, flawed. My lord, why do I say it's flawed? My lord, kindly have a look at, my lord, ArcelorMittal first. I'll find my name. What's the reference?
Judgment গুলো দিয়েছিল তো আগে কম্পারিজন করে দিয়েছিল
Huh? Yeah, yeah. 2019 to SCG 1, I don't have it. I had it loose. Yeah.
Last page of your written note, you referred to it. The last page.
Yeah, yeah. Mhm. You gave it now, ArcelorMittal, in your compilation. I've given, but did you have it in your compilation? No. My lord, it would be loose, my lord. My lord, my learned friend gave a compilation in yours. Yes, yes. Compilation ta dekhun okhan theke. My lord, I had given it also, my lord, but I'm told it's in, my lord, my learned friend's compilation. Amay din ami bar kore dicchi. नहीं फर्स्ट नहीं है this is yours.
This is ours. Item 1. No. No, this is loose here. It should be loose only.
লুজ থাকবে তো ওইটাতে দুটো আছে দেখুন কি আছে মাঝখানে নাও স্যার ওটা নয় কেস No, that's what I thought. I had given. No, please. Yes.
তুমি পুরোটা দাও আমি দেখে নিচ্ছি
Yes, that's there, my lord. এরকম দুটো থাকবে It's there, my lord. It's
কক্স এন্ড কিংস এটা নয় এটা নয় আর্টসেলের মিত্তল দেখো এটা কক্স এন্ড কিংস তুমি বাঞ্চটা দাও তো
नहीं,
পুরো আমাকে পুরো বাঞ্চটা
मतलब
দাও
I'll just
it will be quicker
But what are you doing?
yes I've got wait a second Path that report. Yes, you've got Arsenal.
Now, my lord, kindly come to my lord ArcelorMittal, my lord, which was relied on by the learned judge. My lord, I had, my lord, referred to ArcelorMittal to show, my lord, that, my lord, it was not really that relevant for our case because it wasn't, my lord, a case under the Arbitration Act. But secondly, also, my lord, in any view of the matter, my lord, it shows, my lord, that control has to be positive control and not, my lord, negative control. And negative control is 25 above 25%, but below, my lord, 50%. Now, my lord, first, my lord, kindly have a look to paragraph 1. What, my lord, the issue, my lord, was involved, the issue that was involved there. The facts of the present case revolve around the ineligibility of the resolution applicants to submit resolution plans after introduction of section 29A into the Insolvency and Bankruptcy Code with effect from. Because your lordship's aware, my lord, that, my lord, a resolution applicant cannot himself, my lord, be, my lord, in control of, or, my lord, company, my lord, which has defaulted. So, my lord, defaulters are being kept out, my lord, of, my lord, the purview when deciding, my lord, who will take over, my lord, financially stressed companies.
Yes.
Now, my lord, this was, my lord, the issue. Now, my lord, kindly come to, my lord, paragraph 26, my lord.
Yes.
My lord, finally, the Insolvency and Bankruptcy Code Second Amendment received the assent of the President on 17th August 2018, but came into force with retrospective effect from 6th June 2018. Amendment inter alia amended 29A, which reads now as follows. Then, my lord, we were really concerned in ArcelorMittal on 29AC, my lord, that a person shall not be eligible to submit a resolution plan if such person or any other person acting jointly or in concert with such person, C, at the time of submission of the resolution plan has an account or an account of a corporate debtor under the management and control of such person or of whom such person is a promoter classified as non-performing asset in accordance. So, my lord, question was, my lord, whether, my lord, the Mittals, my lord, were disqualified in, my lord, bidding, my lord, here. Now, my lord, para 29.
Yes.
It is in this background that the section has to be construed, my lord, considering the, my lord, speech of the finance minister and the objects and reasons. Has to be in Ezra and state the court, after referring to the golden rule of literal construction and its older counterpart, the object rule, in Hayden's case refers to the theory of creative interpretation as follows. Then, my lord, kindly come straight away to, my lord, paragraph 48. I'm sorry, my lord, 45. 45, which is, my lord, if your lordship has the print, my lord, 61, at page 61.
Yes.
When we come to clause C of section 29A, the first thing that was argued, at which the parties were at loggerheads, was the time at which clause C can be said to operate. According to Sri Rohatgi, in the original clause C pre-amendment, the time must necessarily be the date of commencement of the corporate insolvency resolution process, as is mentioned by the section itself. According to Messrs. Salve and Singhvi, it is clear that since submission of a resolution plan is spoken of, it is the time of submission of such plan and not at any anterior stage. According to us, it is clear that the opening words of 29A furnish a clue at the time at which clause C is to operate. So and so of section shall not be eligible to submit. It is therefore clear that the stage of ineligibility attaches when the resolution plan is submitted by a resolution applicant. So, my lord, that's the time. Now, my lord, what had happened there, my lord, 5 days before submission, my lord, they sold off their shareholding in another company which had an NPA. So, my lord, the interpretation given was, my lord, just prior to, after this finding, just prior to that, my lord, if an action is taken to come and qualify here to submit it, that also won't be permitted. In fact, it's a 142 order here. Now, my lord, kindly come to 49. This is, my lord, the important.
Yes.
The, my lord, we had here, my lord, C was being, my lord, dealt with, 29AC. Now, my lord, kindly come to the expression control is defined in section 227 of the Companies Act 2013 as follows. 227. Control shall include the right to appoint majority of the directors or to control the management of policy decisions exercisable by a person or persons acting individually or in concert, directly or indirectly, including by virtue of their shareholding or management rights or shareholder agreements or voting agreements or in any other manner. The expression control is therefore defined in two parts. The first part refers to de jure control, which includes the right to appoint a majority of the directors of a company. The second part refers to de facto control. So long as a person or persons acting in concert, directly or indirectly, can positively influence in any manner management or policy decisions, they could be said to be in control. A management decision is a decision to be taken as to how the corporate body is to be run in its day-to-day affairs. A policy decision would be a decision that would be beyond running day-to-day affairs, that is long-term decision. So long as management or policy decisions can be or are in fact taken by virtue of shareholding, management rights, shareholder agreements, voting agreements, or otherwise, control can be said to exist. Thus, the expression control in section 29AC denotes only positive control, which means that the mere power to block special resolutions of a company cannot amount to control. Control here, as contrasted with management, means de facto control of actual management or policy decisions that can be or are in fact taken. A judgment of the Securities Appellate Tribunal in Shubhkam Ventures made the following observations qua control under the SEBI Substantial Acquisition of Shares Takeover Regulations 1997, wherein control is defined in Regulation 2(1)(e) in similar terms as Section 227 of the Companies Act 2013. The Securities Appellate Tribunal held, and my lord, I'm just placing because this is what is relied on. The term control has been defined in Regulation 2(1)(c), take it out, the Takeover Code, of the Takeover Code to include the right to appoint majority of the directors or to control the management of policy decisions exercisable by a person, etc. This definition is an inclusive one and not exhaustive, and it has two separate, distinct and separate features: the right to appoint majority of directors or the ability to control the management on policy decisions by various means referred to in the definition. This control of management of policy decisions could be by virtue of shareholding or management rights, or shareholders' agreement, or voting agreements, or in any other manner. This definition appears to be similar to the one given in Black's Law Dictionary, where this term, direct or indirect powers to direct management and policy, whether so and so. Control, according to the definition, is a proactive and not a reactive power. It is a power by which an acquirer can command the target companies to do, kindly note this, what he wants it to do. Control really means creating or controlling a situation by taking the initiative. Power by which an acquirer can only prevent a company from doing what the latter wants to do is by itself not control. In that event, the acquirer is only reacting rather than taking the initiative. It is a positive power and not a negative power in a board-managed company. It is the board of directors that is in control If an acquirer were to have power to appoint majority of directors, it is obvious he would be in control. But that is not the only way to be in control. If an acquirer were to control the management of policy, he would be in control. This could happen by way of his shareholding or management rights or by reason of shareholder agreement. The test really is whether the acquirer is in the driving seat. To extend the metaphor further, the question would be whether he controls the steering, accelerator, the gears, and the brakes. If the answer to these questions is in the affirmative, then alone would he be in control. In other words, the question to be asked in each case would be whether the acquirer is the driving force behind the company and whether he is one providing motion to the organization. If yes, he is in control, but otherwise, in short, control means effective control. We think they are opposite and apply to the expression control in 29 AC. So, my lord, Companies Act considered, my lord, Takeover Code considered, and my lord, the IBC 29A, my lord, considered. Control, my lord, even, my lord, if it were to be extrapolated, my lord, for the purposes of, my lord, the schedule, my lord, it has to be, my lord, effective control, proactive control, not reactive control.
Yes.
My lord, it could be de jure, the right to appoint majority, which it doesn't have. Then, my lord, de facto, where, my lord, there has to be evidence of this, my lord, happening. My lord, on day-to-day management or in framing of policy decisions. And this is something which could continue because of, my lord, a shareholding arrangement or a voting arrangement or otherwise. There has to be an element of permanency, my lord, which in a given set of situations can, my lord, be said to be attracted if it's happened, my lord, with frequency, such frequency, my lord, that it has to be assumed that there is an unwritten arrangement. So that the board, my lord, even, my lord, though it's de jure in control, cannot, my lord, say no to, my lord, the de facto control. Now, my lord, yeah, give me the takeover code, I'll just show it. Copies. My lord, I believe these were given last.
Yes,
One
should have
just
been.
hand
Yes,
up,
must
check
be.
whether they are the right
Your code
ones.
was
What is it? Do you know whether they are the right
what
ones?
code?
I think it's there in the same.
No,
Not that.
it is highway guidance. It is highway. It all code is
এরকম লেখা থাকে ভারত's manual of SEBI Act.
So,
My lord, the cover page should be Bharat's manual of.
yes, yes, SEBI.
Yes. So, my lord, it's just, my lord, to show, my lord, that what the definition, etc.
Yes.
That's, my lord, dealt with in ArcelorMittal itself.
Yes.
Now, my lord, kindly have a look. My lord, apropos, my lord, this finding itself, my lord, kindly have a look at, my lord, volume 10. Sorry, my lord, I'm.
কন্টেন্টটা দাও
Volume 10, volume 10.
বুঝতে পারছো না নাকি বাসু
First, my lord, page 13. There's a supplementary affidavit at page 1335.
Yes.
But before that, my lord, I just want to show your lordships, my lord, 1325. In fact, from my lord, paragraph 39 onwards. My lord.
All right.
My lord, page 1324 first, my lord, 1324.
What is this? This is a
My
part.
lord, affidavit, my lord, filed by my lord, my learned friends' clients. My lord, it's the affidavit in rejoinder of Anil Bagri, son of Gopal Das Bagri. It starts at page 1306
All right. Yes.
in the 34, my lord. Now, my lord, kindly come to paragraph. Yeah. My lord, page 1324, my lord.
Yes.
My lord, paragraph 38, my lord, onwards. It is submitted that, my lord, under that heading, my lord, Triple SMIL is a public limited and was not wholly controlled by respond number 2. They're dealing with that.
Right.
It is submitted that basis the information available in public domain, Triple SMIL was originally incorporated on so-and-so as Chem Crown by respond number 2. No dispute, my lord. My lord, subscriber to the memorandum and articles, my lord, in 1973. It made its public issue, kindly note this, in the year 1991 and subsequently got its shares listed at Bombay Stock Exchange and so-and-so. Then, my lord, as on 31st December 2019, during the pendency of the arbitral proceedings, the shareholding pattern of SSMIL showed that the promoter group, that is, respond number 2 along with his group companies, namely BG Chemical so-and-so owned 30 and the remaining 64.58% shares were held by the public. Chart below shows the shareholding pattern of SSMIL. Now, my lord, kindly come to individuals, Hindu undivided family within promoter and promoter group. My lord, 9.67. Kindly make a note of this because this promoter group doesn't feature, my lord, in the finding of the learned judge. And my lord, who the promoter group is, my lord, will come out later. Now, my lord, BG Chemicals Private Limited, 25.68%. This is, my lord, the shareholding. Chem Crown Exports Limited within promoter and promoter group, 0.8%. Then, my lord, public, 64.58%. Now, my lord, BG Chemicals was owned and controlled before where it was also established that the promoter group directly, exactly. So, on the basis of shareholding alone, my lord, it's being asserted, not any other overt act that, my lord, they are in control and management. Now, my lord, kindly come to the supplementary affidavit, which starts at 1335.
Yes.
My lord, owing para 2 says, owing to, my lord, a mistake, my lord, certain shareholding patterns, my lord, were not, my lord, annexed. That your lordship will now come to, my lord, page 1351. My lord, it's folded, my lord.
Yes.
1351. This gives, my lord, 31st December quarter. The typed copy is 1351, then 1352. And let certain queries. Now kindly come to 1353. Typed copy, my lord, is at 1353A. Now, my lord, number of shareholders. Kindly have a look. 108. It's clearly, my lord, not family members. Now, my lord, this, my lord, is made at 35.42. Now there's a breakup, my lord. Kindly come to, my lord, individuals and any other at page 1355. My lord, the typed copy is 1355A.
Yes.
My lord, that any other, my lord, is BG. And, my lord, another entity that Chem Crown exports, your lordship would recall. Now, my lord, then is individuals / Hindu undivided family 106. 9 point. So there are 106 shareholders, 9.67. Now, my lord, kindly come to, my lord, page 1355. My lord, kindly come straight away to 1359, my lord.
Yes.
Saroj Devi Bhaiya.
Hmm.
Then, my lord, Krishna Devi Bhaiya. Then, my lord, Rajkumar Bhaiya. Ramesh Kumar Maheshwari. Jamna Devi Bhaiya. Krishna Kumar Maheshwari. Madhu Bhaiya. My lord, these are, my lord, Bhaiyas.
Appears from the PAN that they were sleeping shareholders.
No, not just sleeping. My lord, they are not even direct family, my lord, of Bulaki Das Bhaiya.
On the PAN number.
Correct. PAN number, yes. Your lordship's right, my lord. And, my lord, what should have been, in all fairness, because we are relatives, should have pointed out, my lord, who these persons are. My lord, younger brother's wife is Saroj Devi Bhaiya. Then, my lord, Krishna Devi Bhaiya, my learned friend will correct me if I'm wrong.
He doesn't know.
My lord, he is my brother-in-law.
No, Mr. Diwan does. He'll have to take instruction.
Yes, of course, you can
He'll have
get
to take
instruction.
Yes.
My lord, elder brother's daughter-in-law. Then, my lord, Rajkumar Bhaiya, older brother's son. Ramesh Kumar Maheshwari, younger brother. Then, my lord, Jamna Devi Bhaiya, elder brother's wife. Krishna Kumar Maheshwari, elder brother's son. And Madhu Bhaiya, wife of Rajkumar Bhaiya, daughter-in-law of older brother. And, my lord, kindly see, my lord, their shareholdings are also given. There's not one allegation that any one of these persons, my lord, it's not been relied on in the judgment, nor in the affidavit, that all these persons are under the control of, my lord, BD Bhaiya.
Generally stated that Bhaiya and
Bhaiya controls.
controls.
And this is the promoter shareholding. So entire promoter is Bhaiya.
We'll just come back in
Yes.
terms.
Now, my lord, I go, my lord, to, my lord, the next point, my lord, apropos, my lord, why, my lord, first is, my lord, on control. Now, my lord, the second is, my lord, affiliate. Now, my lord, I think, my lord, the learned judge held in my favor, my lord, in that first sentence, my lord, my lord, paragraph
54.
54, my lord, at page, my lord,
1592.
59, my lord, 59. My lord, 1592, my lord. Para 54, my lord, 1592. That SSMIL is an affiliate of CNE of Bhaya Group. The two companies are not, my lord, and I've shown, my lord, the explanation to the schedule. There has to be a parent. There is no evidence, my lord, of that. But, my lord, what the learned judge goes on to hold, my lord, is, my lord, that the individuals, the said Bulaki Das Bhaiya and his family directly or indirectly control and manage so-and-so and CNE. And the latter two companies function as per wishes and dictates. This court is therefore of the view that individual or group of persons, including a family in control, qualify as an affiliate within the meaning of explanation. So, my lord, individuals, you lift the veil of both companies, you see the same individuals, and these individuals are affiliates. And, my lord, in any event, they are affiliates, my lord, of Bhaiya. Now, my lord, the first submission, my lord, I make apropos this is, my lord, what has been statutorily engrafted envisages, my lord, an affiliate to be a corporate entity. It cannot, my lord, be individuals.
Yes.
Second, my lord, is that, my lord, this is, my lord, the, my lord, explanation to 12.1
Yes.
and this schedule, my lord, arises, my lord, is, my lord, bodily lifting only, and I'm kindly note this, only the guidelines of the IBA, not anything else. It is only the guidelines, which is why, my lord, the section our statute, my lord, categorically provides shall act as a guide, if I'm not mistaken, my lord.
Yes, yes.
My lord, it says, my lord, shall guide in determining. It's, my lord, so, my lord, the guidelines only have been taken. My lord, after considering Law Commission report, my lord, what has found place in the statute is only, my lord, the guidelines. And, my lord, these, my lord, are, my lord, the 2014 guideline. My lord, I'd given, my lord, a copy, my lord, of the 2014 and the 2024 guideline.
Yes.
Now, my lord, the 2014 guideline,
Very good.
PDF page 11. What is PDF page? What's wrong with you? Ramesh. Wrong with you? What's wrong with My lord, kindly have a look, my lord, at my lord, my lord, in my lord, the guidelines, my lord, which my lord start with my lord, the lists which are given here, my lord, that is, I'll come to my lord HRD, my lord, it puts them side by side, my lord.
Hmm.
My lord, this, my lord, is the list. Kindly come to page 21, my lord.
Yes.
Your lordship will find, my lord, footnote 4.
Hmm.
Throughout the application list, the term affiliate encompasses all companies and a group of companies, including the parent. This explanation has been bodily lifted and, my lord, put into, my lord, the, my lord, schedule.
Hmm.
Now, my lord, the schedule has come from these lists only. That I wish to show your lordships, my lord. Kindly take HRD's case, my lord, which is, my lord, 2018 12 SCC 471.
Yes. So ArcelorMittal.
Yes, my lord, the fifth schedule.
Yes. ArcelorMittal পরে। তারপরে। এই যে, Yes.
My lord, at para 11,
Hmm.
my lord, your lordship will find, my lord, the fifth schedule, my lord, has been, there's a table, my lord, at para 11, page 482.
Yes.
Now, my lord, this, my lord, juxtaposes, my lord, the corresponding provisions in the IBA guidelines, which have been taken. And, my lord, explanation 2 at 487, your lordship will find.
Hmm.
My lord, explanation 2, the term 487. Explanation 2, the term affiliate encompasses all companies in one group of companies, including the parent company. And, my lord, footnote 4, throughout the application list, the term affiliate encompasses all companies in a group of companies, including the parent company. Straight away, my lord, from there.
Only A has been replaced as 1.
Yes, my lord.
Yes.
Lordship's right, my lord. In A and my lord, that one.
That
Yes,
is-
yes. No, my lord. I'm saying, my lord, they all come from the list.
Yes, yes.
Now, my lord, important thing is,
Yes.
there was an amendment, my lord, in 2024 to, my lord, the IBA, my lord, guidelines.
Yes.
That, my lord, has not been incorporated, my lord, in, my lord,
Yes.
our statute. That your lordship, my lord, will find my lord, in the 2024 guidelines,
Yes.
my lord, page 15, my lord, paginations at the bottom,
Page 50.
and it reads, my lord, throughout the application list, the term affiliate encompasses all companies in a group of companies, including the parent company and or, kindly note this, an individual having a controlling influence on the party in the arbitration and or any person or entity over which a party has controlling influence. My lord, individuals, my lord, have also been put in by way of explanation, my lord, in the 2024 guidelines. Specifically, which has, my lord, not been, my lord, put in place by an amendment in our statutory framework. And the arbitration agreement here, my lord, does not incorporate the IBA guidelines. My lord, it would have been another matter, my lord, if the agreement itself, my lord, incorporated either ICC or IBA, my lord, then, my lord, we, my lord, could, my lord, argue that these standards were also required to be followed.
It changes with the alteration in
Correct, correct.
as you said, bodily lifted from the previous one.
Absolutely, absolutely.
So
And recognized to be so, my lord, by the Supreme Court in that judgment itself.
yes,
I'll, my lord, I'll show that paragraph.
recognize your exposure. What?
Yeah. So, my lord, I just wanted to show this paragraph first. And then, my lord, to the judgment itself, there's another paragraph.
So, but specific implication, this was not there.
Correct.
Now it has been put in.
Yes. At
So
the relevant time, my lord, it
it was
was.
not there. So, very well.
Now, my lord, how are these, my lord, guidelines to be interpreted?
Mr. Mukherjee, can we find anything? We are speaking against you. In this 2024 guidelines to indicate that these are clarificatory in nature.
No,
like,
it's not there. It's not a clarification. It's not.
Like legislations.
It's not. It's not. Now, my lord, in fact, my lord, if your lordships, my lord, kindly have a look at, my lord, the judgment in HRD, my lord, that is, my lord, 2018-12 SCC 471. My lord, your lordships, my lord, are aware, my lord, IBA, my lord, is really, my lord, an association of, my lord, legal practitioners, my
Yes.
lord, from different regions of the world who come and give, my lord, their
Best practices and
yes, and their experiences,
experience.
my lord, in, my lord, a particular, my lord, situation. And it's forever evolving. And every 10 years, my lord, they come out, my lord, with guidelines. Now, my lord, kindly see, my lord, paragraph 20. My lord, sorry, my lord, kindly come to paragraph 16, my lord.
Yes.
My lord, this is, my lord, if subject to correction, my lord, Voshtalpine, my lord,
Yes.
Shen and GmbH versus DMRC is, my lord, a case, my lord, where, my lord, it's for the first time that these guidelines came to be considered, my lord, by the Supreme Court. So, my lord, it's, my lord, referred to here. Then, my lord, comes paragraph 19, my lord. Sorry, 20. However, my lord, one of the submissions that were made, my lord, was look, when you interpret these guidelines as they are engrafted in our statute, one must give the words expressed the widest possible meaning.
Yes.
Reason being that, my lord, the grounds of challenge for an award, my lord, have been really limited after the 23rd October 2015. My lord, relying on associated, my lord, after associated, my lord, there was a narrowing, which is reflected, my lord, in the
So sorry, there was an
narrowing, my lord,
narrowing.
of the grounds of interference.
Yes.
That is, my lord, recognized in Sangyong, my lord, commented on. And, my lord, what was relied on here, my lord, was the Law Commission report that led to, my lord, these amendments. My lord, they were with retrospective effect from 23rd October. Though, my lord, the Act, my lord, came into effect in December because of the ordinance. And it was all based on the 246 Law Commission report that we need to curtail the grounds for interference. And particularly regarding international arbitration. And by international, by it's a domestic in the sense that the arbitrations held in India, but the one of the parties is foreign. So, my lord, because we have 2A for, my lord, purely domestic awards where both parties are Indian.
Yes.
Now, my lord, kindly have a look at para 20. However, to accede to Sri Diwan's submission that because the grounds for challenge have been narrowed as aforesaid, we must construe the items in 5th and 7th schedule in the most expansive manner so that the remotest likelihood of bias gets removed is not an acceptable way of interpreting the schedules. My lord, I pause here. So it can't be, my lord, the widest form. Now, my lord, next. As has been pointed out by us herein above, the items contained in the schedules owe their origin to the IBA guidelines, which are to be construed in the light of the general principles contained therein, that every arbitrator shall be impartial and independent of the parties at the time of accepting his or her appointment. Now, my lord, this is exactly what's recognized in 12.1. Then, my lord, doubts as to the above are only justifiable if a reasonable third person having knowledge of the relevant facts and circumstances would reach the conclusion that there is a likelihood that the arbitrator may be influenced by factors other than the merits of the case in reaching his or her decision. This is really the test. And, my lord, the schedules operate, my lord, as guidelines. Now, my lord, as my lord, Your Lordship Justice Bhattacharya had occasion to point out that, my lord, if, my lord, your Lordship had, my lord, taken, my lord, a matter when in the bar, my lord, for a particular client, even in an unconnected matter, my lord, your Lordship would not be appearing.
That was not the general.
No, it's not.
thought. It was
So, my lord, there's a subjective view, there is an objective view.
yes.
And what is being stressed here is not what the disclosure Mr. Kapoor made, which was a completely subjective view at that time, but it is the third person, that is the test. And the guiding factors are Schedule 5 and Schedule 7.
But reasonable is used, Mr. Mukherjee. We are, I mean, we are keep making it open.
Yes,
Reasonable is used so many places,
yes.
everywhere, throughout
Everywhere.
our statute books and everything.
Yes.
So reasonableness is also subjective.
Yes, my lord, I'll tell your lordships, my lord, this came up. Just if I may digress for a moment.
Reasonableness is as arbitrary as arbitrariness.
Absolutely. Now, my lord, I'll tell your lordships why, my lord.
Yes.
My lord, the test was the reasonable man on the Clapham omnibus.
I didn't know that.
My lord, for my lord,
Original.
yes. Now, my lord, Clapham omnibus, my lord, would have, my lord, men who probably, my lord, were not, my lord, those who were fortunate enough to have a very good education. So it needn't have been, my lord, someone who's, my lord, well instructed.
Rather, it should not
Yes,
be.
yes.
Because the more educated and intellectual you are, then the more types of interpretations, it's open to more interpretations.
So it's the common man, really. So, my lord, if now, my lord, we are looking at.
Most difficult to be common.
Yes, it is. So, my lord, that is, but the test is, my lord, that it aims to be objective by saying a third person, my lord, having knowledge of the relevant facts and circumstances. How would they, my lord, view it? And for that, my lord, the guiding factor is, my lord, the schedule. This is what it is. And it's not to be interpreted widely simply because grounds of challenge are, my lord, cut down. Then, my lord, it says, this test requires taking a broad, commonsensical approach to the item stated. Again, my lord.
Reasonableness.
Yes. This approach would therefore require a fair construction of the words used therein, neither tending to enlarge or restrict them unduly. It is with these preparatory. This is, my lord, the position. Now, my lord, if I'm right in my submission that this was not clarificatory, And my lord, it wasn't even there, my lord, as a guide. My lord, when, my lord, the incident occurred, then, my lord, you cannot look at affiliation between individuals. Though I say it cannot be done in this case at all because there's no control as far as triple SMIL is concerned. Because it's only 26%. CNE admittedly is over 90%. Both are claimants,
Yes.
my lord, in arbitration.
We have to look at the contours of 2019. In fact, 2024 this came in.
Correct.
So in any event, probably we cannot, because
Correct.
it was the duty of the arbitrator to disclose that
Correct.
in 2019.
Correct.
The award came in
Correct.
2019. Before that,
Before that, my lord, 2018.
2018. So
That
therefore,
intervening 1 year
yes.
where he is supposed to have appeared, my lord, 10 occasions. My lord, name went down for 10. But I don't know, my lord, how many.
How many actually? Anyway,
I'll take it as 10, my lord.
11. It's
Wait,
stated 11.
11. I'll take it as, my lord, 11. My lord, I checked with, my lord, Mr. Ghosh, my lord, and he says, I remember him only once.
But even then, that's there on record, sir.
Yes, my lord. So, my lord, I'm not. Now, my lord, kindly take, my lord, and then I come back to the judgment again. So, this is, my lord, my first submission, my lord, was, my lord, on the foundational findings, my lord, the judgment, my lord, is clearly erroneous. With the greatest of respect, my lord, to the learned judge. Now, my lord, kindly take, my lord, what are you trying to say something? No, I'm fully aware of what I'm doing. You know, when I go to bed, I think about matters. Now, my lord, sorry. My lord, kindly see the question, my lord, which has been put here. Has the arbitrator rendered himself ineligible under 12(2) and 5 and grounds 2, 11, 15 and 20 of the 5th schedule and grounds 2, 8 and 15 of the 7th schedule of the Act of 1996. Now, my lord, kindly have a look at these. My lord, 12(2) I have shown, my lord, it's a continuing duty. I don't need to trouble your lordships with that. Kindly have a look at 2, 11, 15 and 20 of the
5th.
Yes. Now, my lord, 2 is the arbitrator current, I'm sorry, my lord, 5th schedule, item 2, my lord.
Yes, it's with.
The arbitrator currently represents or advises one of the parties or an affiliate of one of the parties. This is, my lord, the first. Then, my lord, we have, my lord, 11. The arbitrator is a legal representative of an entity that is a party in the arbitration. My lord, some of them clearly don't apply on the face of it, my lord. I'll eliminate those first, my lord. Then, my lord, kindly come to 15. The arbitrator has given legal advice or provided an expert opinion on what? On the dispute to a party or an affiliate of one of the parties.
No.
Then, my lord, kindly come to 20. The arbitrators has within the past 3 years served as counsel for one of the parties or an affiliate of one of the parties, or has previously advised or been consulted by the party or an affiliate of the party making the appointment in an unrelated matter, but the arbitrator and the party or the affiliate of the party have no ongoing relationship. So this takes it back, my lord, to 3 years and has served as counsel of the party or an affiliate of one of the parties. So, my lord, now, my lord, if we are looking at, my lord, 2, 11, 15 and 20 of the 5th schedule. My lord, if I'm right in my submission vis-a-vis affiliate, Then, my lord, 2 goes out of the picture. And, my lord, 20 also goes out of the picture.
Affiliate.
Yes. Straight away. Now, my lord, if I'm wrong in that, my lord, 2 has been interpreted in HRD. When it was dealing, my lord, it says that it has to be, my lord, not, my lord, an engagement, my lord, for just a particular. There has to be a ongoing relationship.
But 11 appearances may tantamount to that.
Question is, what is a legal representative?
All right. You are trying to differentiate between legal representative and counsel.
Yes. My lord, counsel is one, but even 11 won't be attracted because it has to be a party in the arbitration.
Legal representative, yes. And
To a party in the arbitration.
and to a party.
My lord, there is no case of, my lord, party. No evidence. My lord, the only thing is case appearance. Case is SM.
The triple S.
Correct.
That company is the
Correct.
is the
Yes.
eye of the stock.
Correct. And who's not a party, my lord, to the arbitration. So 11 also, my lord, will not apply.
It is nobody's case that he appeared for Bulaki.
No. The Bulaki wasn't, my lord, there in any litigation. And then, my lord, 15, my lord, is giving advice on the dispute. It's nobody's case.
Yes, on the dispute.
So, my lord, really, my lord, I need to, my lord, deal with, my lord, 2 and 20.
Yes.
Now, my lord, kindly have a look at the 7 schedule. My lord, 2, 8 and 15.
Yes.
My lord, 2, my lord, is the same as 5th schedule 2 is 7th schedule 2.
Yes.
Then, my lord, kindly come to, my lord, 8. The arbitrator regularly advises the appointing party or an affiliate of the appointing party, even though neither the arbitrator nor his or her firm derives a significant financial income therefrom.
Appointing party means?
There is no party appointment here, my lord.
No, therefore.
Doesn't apply.
It was the appointment was by section 11.
No, there was a suit.
Oh,
Court suggested, my lord, that you should settle, and they proposed.
They proposed that. Therefore,
and it was accepted by court and court appointed. So this doesn't apply, my lord, at all. And then, my lord, 15 is, my lord, relationship of the arbitrator has given legal advice or provided on the dispute. My lord, dispute is, my lord, not. And 8, my lord, envisages regularly advising. There's no case, my lord, of regularly advising. Now, my lord, in this context, kindly see, my lord, the, my lord, submissions. The question, my lord, which has been put, whether there has been, and now, my lord, kindly see, my lord, just your lordships may, my lord, make, no, I'll, my lord, show it. It's much better that way. My lord, para 55. The preliminary question in the application under section 36(1) and section 34 is whether by reason of appearing for SSMIL on several occasions, the learned arbitrator rendered himself ineligible to continue the arbitral proceedings in an impartial manner. In other words, whether the arbitrator has fallen foul of any of the grounds under the 5th schedule and the 7th schedule under so. Now, my lord, I pause here for a moment. My lord, that could not be an issue in the 36. 36, my lord, waiver, my lord, for deposit, my lord, is only, my lord, whether there is fraud or corruption. It's not, my lord, on an apprehension of bias or, my lord, a particular provision relating to appointment. Disqualification is not an issue. Then, my lord, para 56, my lord, onwards, my lord, is, my lord, the submissions of, my lord, the parties. Kindly come to 59. This court need not enter into an inquiry as regards whether the Bagri group came to know of the alleged impropriety of the learned arbitrator. That's one of the extracted portions of the affidavit that you had knowledge. Then what is important is whether the same would attract ineligibility under 12(2) and 5. Then, my lord, para 62, my lord, kindly have a look. Given the very limited scope of challenge of an award under 34, the requirement of neutrality of the arbitrator has assumed the highest importance. No matter how fair and judicious an award may be, one cannot be oblivious to the fact that there is one side who will succeed in receiving the huge financial benefit and the other side shall be liable for the same. The consequence of the award and the limited scope of challenge for the same are far-reaching on the parties. Now, my lord, I see, my lord, the direction which is being adopted, my lord, by the learned single judge is contrary, my lord, to the principle in HRT. Now, my lord, and this, my lord, is, my lord, what really determines, my lord, outcome. Kindly come now, my lord, to paragraph 66, my lord, Vaushal, Payne, Himadri, they have all been, my lord, quoted here.
Yes.
Then kindly come to, my lord, paragraph 66 to 69. In this backdrop, the Arbitration and Conciliation Act came to be amended. The object and purpose behind the amendment with regard to the findings of the Law Commission have been dealt with at length in Vaushal. In this regard, Jaipur Zilla Dukh is also referred to. Then, my lord, this court is, however, not inclined to accept that the non-disclosure by the arbitrator having represented SSMIL in the High Court during the pendency of the arbitration would amount to fraud. Admittedly, to establish fraud, a very high degree of proof is necessary. The same is required to be preceded by sufficient particulars included in the application under, it should be 36 of the Act. Sufficient particulars are not available in the application or the affidavit filed to the application under so and so. Mr. Kohli has, now kindly note this, candidly submitted in the course of his arguments that his clients do not wish to press the argument of corruption and bias against the arbitrator. In the above circumstances, the issue of fraud is not dealt with. This court, even otherwise, does not find any fraud having been committed by the arbitrator in the proceedings. Now, my lord, what is important is, my lord, even bias, my lord, goes out. My lord, it can have several other consequences, my lord, on bias. My lord, I won't take it to the limit of saying that even if bias had been given out, my lord, given up, the court could not consider, my lord, violation of these schedules. I'm not going to argue that. It might have been a futile exercise, could be one argument, but my lord, there are cases which suggest that even by mistake, if it has not been complied with, even by mistake, if it's not been complied with, court can look into it. Because, my lord, kindly note one thing.
Don't go to the level of bias.
Yes, no bias. It could give rise, because neutrality, my lord, is justice must not only be done, must be seen to have been done, and from the third party's point of view, who given the facts of the case.
Absolutely.
So, my lord, here parties appearing before him, even after 2018, my lord, felt, my lord, that there was, my lord, no, my lord, nothing to suggest that there was a bias. Because at times, my lord, during proceedings, we come saying this is what's been happening. A consistent line of directions which suggest and which give us grounds to apprehend a likelihood of bias. Nothing of that sort. Now, my lord, so, my lord, I'm not going to take it, my lord, to that far, my lord. I don't think it will be fair. So, my learned friend, my lord, cannot labor so much on it, my lord, as he did, my lord, on the... Because even a mistake, my lord, can, my lord, give rise to this situation. In fact, my lord, they've been very careful, my lord, not to show, my lord, that any part of the award is wrong, other than saying, oh, they've got a huge amount, I've got a paltry amount. Now, my lord,
there need not be any menstruity attributed to the...
Correct.
So,
in the above circumstances, the issue of fraud, but at least, my lord, they've got out by saying the preliminary issue is the same. They've got out from furnishing security. Because having tagged both together, Millard, that was Millard, and then giving it up during the course of hearing. It is, however, necessary to consider whether the arbitrator representing so-and-so during the pendency of the arbitration would either constitute bias or act likely to suggest or indicate bias on the part of the arbitrator. Perhaps, my lord, if bias had been given up, this was not the question to put. The question ought to have been, has there still been an infraction of Millard, the Millard provision?
12.5.7.
12.1, 5, and Millard, the 5th schedule and the 7th schedule. 12.1, 2.
By 5 and 7,
Yes, the schedule. Now, Millard, then Millard, several cases are relied on.
Yes.
Kindly come to Millard. Paragraph Millard 73. In the backdrop of the above, the court notices that having once made a disclosure in the first sitting that the arbitrator and his family members were connected with and represented the Bhaya group in CS 344. Now, my lord, I pause here. My lord, who was my lord Bhaya group in CS 344? My lord, Bhaya and CNE. The learned arbitrator was obliged not to represent them any further. So, my lord, CNE and Bhaya, he ought not to represent. Then, my lord, the object and purpose of the disclosure in terms of 12.2 essentially means that the arbitrator shall not, during the subsistence of the proceedings, continue such association. The tenor of the arguments of Mr. Ghosh is that once the arbitrator makes the disclosure of being associated in the past with one of the parties in the litigation, he is given a carte blanche by the parties to continue to do so during the subsistence of the proceeding. He can freely associate with the party in any manner during the said arguments deserve to be rejected as preposterous and with disdain. Disclosure by the arbitrator of past association with one party to the arbitration would essentially impose an undertaking on the arbitrator not to do so during the pendency of the arbitration. By representing the arbitrator in representing Bhaya group in APD 252 of 2015, arbitrator has committed breach underlying such disclosure. Now, Millard, this was SSMIL.
And one question which is cropping up in our mind, Mr. Mukherjee, so that it does not pop up when we pass the judgment, we want to put it to you, because here the arbitrator in his initial disclosure had said that I have appeared for Bhaiya and his group companies or something like that in his disclosure.
Correct.
Now we also have to go by the perception of the arbitrator in the sense that if by group companies he meant these companies, then Mr. Diwan may have an argument that that standard should have been applicable now also.
Yes, well, so that has to be shown that these were the
perception
group,
of
these were the group companies.
Yes,
So-
because if he said I had appeared for
Yes.
Bhaiya and group companies previously. Now, therefore, that his perception of the group companies, whether that can be incorporated now to the group company.
Yes, so my lord,
Despite what you are.
yes, now my lord, I have, my lord, two responses to that. First is, my lord, that disclosure, my lord, was, my lord, his subjective, my lord, feeling.
All yes.
That's number one.
That's a good defense. Yes.
Then, my lord, what happens, and this is very important, after that, my lord, there is an amendment to, my lord, 12.1, and, my lord, the guiding factor is Schedule 5 and 7. So, my lord, whether he should make a disclosure or not, my lord, the guiding factor is not just his mind. My lord, it is, my lord, Schedules 5 and 7. Statutorily, my lord. That is number one. Secondly, my lord, it has to be shown that by group companies, it would mean, my lord, companies, my lord, where, my lord, there is, my lord, a, my lord, parent with, my lord, several subsidiaries who are associates of each other. There has to be a parent. Or, my lord, factually it has to be shown that the companies under contemplation included SSSMIL.
So SSSMIL had to be under the same umbrella.
Correct. Of one is parent. Otherwise, my lord, it also
Under the same umbrella or on the same
yes,
bracket?
yes. Factually, it has to be shown that when my lord such a or my lord the group companies were such that they were similar to SSSMIL.
All right.
Which factual basis in my respectful submission, my lord, is not there. But my lord, most important is the standard, my lord, has changed. So that initial, my lord, disclosure and knowing, my lord, his association, my lord, the suggestion is made, my lord, in court.
Yes. Yes.
My lord, and my lord, result is, my lord, I was there for a few days now. Then I said, I can't do this.
The one other aspect also, before parting with affiliate, please tell us. We'll put another question to you on Mr. Deva's last day's submission.
Yes,
That was a very interesting argument.
Yes,
we can
ma'am.
put it.
Yes, kindly put it, my lord.
Because going by the standard of HRT, Mr. Mukherjee, we can neither expand the scope nor restrict. That is also there.
Yes.
Not
So, my lord, it's a common sense approach.
common sense approach.
Yeah.
Now, this schedule, 7th schedule, second item, I mean this, and 5th schedule, the same. It uses the expression the arbitrator currently represents or advises one of the parties or an affiliate of one of the parties. Now here, this parties is
Can be an individual.
can be an individual, and therefore affiliate, whether the affiliate in explanation 2 pertains to only the company where the party is a company.
Whether it would be restricted or
Restricted.
otherwise.
Yes, it's obvious that the term affiliate, and he also stressed on the term, which is was very appealing to us. I mean, that the term affiliate encompasses all companies.
That's an inclusive definition.
Yes.
Yes. So it's not
That is so.
exhaustive.
Yes.
It's
If the
not
party
exhaustive.
is a company, then affiliate, this test would apply. But if the party is, therefore, if that be so, therefore it becomes more fluid in a sense.
Yes. I'll deal with that, my lord. I'll deal with that.
That's a very important argument he made, and which still stays with us. That's
Yes.
why.
No, my lord, of course.
Yes.
And my lord, now, my lord, kindly, my lord, may I just read this and get back?
Please do that. Yes. We just put the question so that I don't forget
Yes.
later.
Now, my lord,
74.
4, my lord. I was at 74, page 1600, my lord. In addition to the aforesaid breach, the arbitrator also suppressed and or failed to disclose before the parties to the arbitration that he has appeared for SSSMIL in so-and-so. The chain of events between December 2017 and 19 would definitely give rise to a real likelihood or danger that arbitrator may have allowed himself to have been compromised and consequently raised justifiable. This court sees the above in no uncertain terms as any reasonable man in the facts of the case. There is clear breach and an infraction of the principle that justice must. It is well established that this court or any court or person cannot enter into the mind of the arbitrator whether there was actual, even threadbare reading of the award does not in fact and law may not disclose. What must be borne in mind that if two views are possible, arbitrator, the court under cannot impose the other clause and interfere in the facts. This court or any court for any would have to invariably doubt as to why they has taken. This is got permitted under hence 12.2 and 5 must be strictly imposed, and given the very narrow scope of intervention within so and so must be strictly and compulsively imposed, such strict compulsive and to ensure that institution, after all, parties are deemed to have imposed piety and reverent faith in the individual or persons to resolve the dispute.
This is a common refrain in the judgment that since section 34 is restrictive, we should be.
Which is contrary to HRD. Well, one should be examined independently by adopting a common sense approach.
But
because
you may very well argue that if section 34 is restrictive, it's for a purpose, legislative intent is that.
Correct.
So you cannot correct that in a sense by giving weightage to additional weightage
Correct.
to something else.
Correct. And that's, my lord, what the Supreme Court has also said, that that basis for interpretation
Yes.
is not right.
Yes.
You please
Because it's-
adopt a robust common sense approach.
Precisely, this was the consideration
Correct.
before the Supreme Court, that
Correct.
just because that's restrictive.
It doesn't mean that. Now, my lord, may I deal with what has fallen from your lordship?
Yes.
Now, my lord, my first point I still argue, my lord, which your lordship says
That
is being
remains.
countered. Now, my lord, kindly have a look at whether 2 applies at all. 2 applies at all, because then only, my lord, the necessity of this, my lord, will arise. Now, my lord, kindly see, my lord, and my lord, I'm just giving this, my lord, as a preliminary, because I'll have to deal with this, my lord, tomorrow or whenever your lordships are
Yes.
taking it next. My lord, kindly take
The present continuous tense probably is relied on the last occasion. That
Yes.
presents.
yes. Now, my lord, your lordship's absolutely right. So that also might have appealed to your lordship. Now, my lord, kindly, my lord, take, my lord, this and, my lord, HRD. My lord, I'll show it from, my lord, HRD itself, my lord, which was dealing with 1 and then dealt with, my lord, 3. 2018, 12 SEC 471. What? 22. Now, my lord, kindly, my lord, see 2 ones, which is the common, my lord, in both. Arbitrator currently represents or advises one of the parties or an affiliate of one of the parties.
Yes.
Now, my lord, I pause here. My lord, where it's counsel, there is a first, my lord, there is a specific provision for counsel. My lord, representing and advising, my lord, can be in any capacity. But, my lord, where, my lord, a counsel is involved, and there could be good reason for it, because, my lord, your lordships, my lord, aware, my lord, of the classical view, one point of time, that, my lord, counsel cannot recover fees if they are unpaid.
Yes.
Because that, my lord, relationship, my lord,
Legal action.
yes. There's, my lord, no, my lord, commercial basis for it. So, in fact,
Yes.
in a wealth tax matter, my lord, there was income tax department, my lord, had said, oh, these are all recoverable. This is to be treated as part of wealth. And, my lord, it was a senior advocate, my lord, of, my lord, our High Court. And, my lord, the circular came out, you can't do that. You can't treat it as wealth. It's not been recovered, he has no recourse. Which is why, my lord, we, my lord, do our, my lord, books, my lord, on cash basis. My lord, whatever comes in is our income. We don't do it like a business enterprise that this is what is receivable. Therefore, it's shown as.
Also, it's not dependent on the result.
Yes, absolutely.
So that's also one of
Yes.
the. It's not profit based.
Yes. Now, my lord. So first, my lord, is where a counsel was, my lord, sought to be, my lord, disqualified to be an arbitrator. There's specific provision. Then, my lord, is, my lord, the lordships, my lord, what your lordship pointed out, the arbitrator currently represents or advises one of the parties. And, my lord, affiliate, I'm saying, my lord, let us take it to be applying. Now, kindly see what the Supreme Court has had to say in a situation like this. Kindly see 1 also, my lord, in this context. The arbitrator is an employee, consultant, advisor, or has any other past or present business relationship with a party. Now, my lord, kindly take para 22 of, my lord, HRD 2018 12 SEC 471, my lord, at 494. Lordships have that, my lord?
Yes.
Now, my lord, kindly see. Shri Diwan has pressed before us that since on a legal issue between GAIL and another public sector undertaking, an opinion has been given by Justice Lahoti to GAIL in the year 2004, which had no concern with respect to the present matter, he would stand disqualified under item 1 of the 7th schedule. Items 8 and 15 were also faintly argued as interdicting Justice Lahoti's appointment. Item 8 would have no application, as it is nobody's case that Justice Lahoti regularly advises the respondent, and item 15 cannot apply as no legal opinion where the dispute at hand was ever given. On reading item 1 of the 7th schedule, it is clear that the item deals with business relationships. The words any other show that the first part of item 1 also confines advisor to a business relationship. The arbitrator must therefore be an advisor insofar as it concerns the business of a party. Howsoever widely construed, it is very difficult to state that a professional relationship is equal to a business relationship, as in its widest sense, it would include commercial relationships of all kinds, but would not include legal advice given. So, my lord, this is, my lord, as far as one is concerned. Then, this becomes clear if it is read along with item 2, 8, 14, and 15. The last item specifically dealing with legal advice. Under items 2, 8, and 14, advice given need not be advice relating to business, but can be advice of any kind. The importance of contrasting item 1 with items 2, 8, and 14 is that the arbitrator should be a regular advisor under 2, 8, and 14 to one of the parties or the appointing party or an affiliate thereof, as the case may be. Though the word regularly is missing from items 1 and 2, it is clear that the arbitrator, if he has an advisor in the sense of being a person who has a business relationship in item 1, or is a person who currently advises a party or his affiliates in item 2, connotes some degree of regularity in both items. The advice given under any of these items cannot possibly be one opinion given by a retired judge on a professional basis at arm's length. Something more is required, which is the element of being conducted in an advisory capacity with a party, has only given profession, which has no concern, is clearly not disqualified.
But this is not a very strong argument with respect to Mr. Mukherjee, because appearing on 11 occasions.
One matter. My lord, in giving an opinion, we can have 11 sittings.
Yes. So he has been representing. Currently represents or advises one of the parties.
Current first is my lord,
It was a
currently.
one of advice by Justice Lahoti.
Yes.
So this cannot be a comparable.
No. So my lord, for my lord Justice Lahoti, my lord, one came into the picture. Here it is, my lord, currently.
Yes.
Currently represents.
Yes.
Or advises one of the parties.
Justice Dariman here says the advice given under any of these items cannot possibly be one opinion given by retired judge.
There has to be regularity.
Something more is required,
yes,
which is the element of being connected in an advisory capacity with a party. Advisory or representative also.
My lord, representation in one litigation, in one case. My lord, is not regular representation. My lord, would it, if I may put a question to myself,
yes,
would it have made a difference if it was one appearance?
Might have, because it's not a question of regular appearances then. One appearance.
In one, my lord, it's one list, because my lord, once we appear.
List may be one, but that party may have only one list. Suppose one company has only one litigation, which is.
My lord, that's one way of looking at it. But it says currently also.
The connectivity is between the arbitrator and this litigant. So whatever may be the number of litigations, now he is regularly appearing for this litigant. In one matter or several matters, that's not a yardstick or parameter here. He is appearing regularly for this entity.
And currently, my lord?
Currently also has a flow in it, in the sense that whenever it was detected, it was pointed out. Currently means we cannot be sure that he has stopped unless it is shown that he has stopped appearing. I mean, he has appeared on 11 occasions.
Yes,
so he's currently
in 2018. In
yes.
2000.
Then currently taken to its logical conclusion will be today he is appearing. I mean, currently maybe he has been appearing recently in a sense. Currently has a, flow about it. Currently he is appearing.
My lord, it's way I look at it, my lord, is currently represents. That's a retainer kind of thing.
Yes, whether that can be reduced to this.
It's a retainer kind of thing that my lord, have a retainer, any matter I represent.
Mr. Mukherjee, have you been currently representing or advising your client in this matter before us?
In this matter,
Yes.
my lord, before your
Would
lordship,
you say that you are, yes, before,
Yes.
not before us or something? Have you been currently representing or advising your client in this matter? Tell us that.
my lord, I take
According to your
instructions from
argument, you are not.
no, I take instructions from my advocate on record.
On at least, say, 10, 11 occasions here.
Yes, my lord, I have taken instructions from my advocate on record when I get engaged. My lord, my lord,
But a senior counsel can also, represent. You are representing your client,
but that's
not acting, but
no,
representing.
true, my lord, but that is specific provision for counsel, my lord, is there because this is my, my lord, quite often,
Hmm.
my lord, we don't see the client.
But Mr. Mukherjee, there is counsel as in which item is?
My lord, first is my lord,
No, 15.
no, first is 4. My lord, lawyer, my lord comes in there.
Yes, yes.
Then, my lord, 1 minute. My lord, law firms, my lord, come in 6 and 7.
Yes, not applicable.
Then, my lord, kindly, my lord, take, my lord,
15 is legal advice. That is
correct. My lord, there, my lord, is, my lord, legal advice on the dispute.
But if you see, the headings are different.
Yes.
15, it's a relationship of arbitration to the dispute and
With parties or counsel.
parties or counsel. So under parties of
My lord, in law, there's probably no relationship at all. In the first, my lord, there'd be no relationship at all. I have a relationship, my lord, with the, my lord,
No, but relationship has been given a form, specific form, including item 2.
correct.
So the arbitrator currently represents or advises one of the parties or an affiliate.
Correct. Now, my lord, if the arbitrator, my lord, is a lawyer,
Yes. He also comes within this.
that's the question. That's another question.
He has not been excluded from this.
No, he is not. But what is, my lord?
Because there is another provision for legal.
Yes.
Which provision are you?
My lord, kindly take.
Legal provision under
lord,
this subheading.
Yes. Now, my lord, first, my lord, take 3. My lord, the arbitrator currently represents the lawyer or law firm acting as counsel for one of the parties.
No, that's on a
Because that's the relationship they will have, my lord.
secondary degree. He represents the lawyer or law firm.
Correct.
Represents the lawyer or law firm is not a good way to put it, actually.
And then, my lord, arbitrator is is a lawyer in the same law firm.
Firm related, these are firm related mostly.
Then, my lord, kindly come to the arbitrator's law firm had a previous but terminated
Not
involvement.
7 is not applicable.
7 is, my lord, commercial relationship.
Law firm.
Law firm.
This is not a question of law firm in your case.
No, not at all. But it's all that I'm showing is, my lord, these are where, my lord, the legal aspect, where, my lord, the legal representation, legal advice issues, my lord, are being concerned.
Now, what we are trying to say is that, Mr. Mukherjee, there is no other provision which deals with representation by counsel, as counsel. So if there is no other provision, then this represents or advises includes counsel also. Because under this subheading or heading, there is no other provision which deals with representation in courts of law or as a counsel. And we cannot pivot on 15 because that is on a different footing relation to the dispute. So it's dispute oriented. And here it's party or counsel oriented. So there is not a single other item which specifically deals with legal representation, apart from 2.
No, 20 has, my lord.
20 is again,
which is, my lord, not
different heading.
No,
Because
maybe different, but kindly have a look, my lord. The arbitrator has within the past 3 years served as counsel for one of the parties.
you are on 5. Yes, 20. Previous service, but the heading is previous service for one of the parties or other involvement in
My
the
lord,
It's previous.
yes, so my lord, not current.
Not current.
Yes, so previous also.
Yes,
Yes.
but the first heading is arbitrator.
My lord, question is whether I come under previous or whether I come under current.
Previously, you
even-
have admitted you come under, you have given a.
Yes, so now kindly see, my lord, if my lord current would include immediately previous, my lord, then I would get disqualified under 2 and 20.
Oh.
Because it doesn't have to be on the dispute. Served
But-
as
but-
counsel.
Yes, all right.
Served as counsel for one of the parties or an affiliate, or has previously advised or been consulted, or an affiliate of the party making the appointment in an unrelated matter, but the arbitrator on the parties have no ongoing
You
relationship.
don't have that advantage in seventh schedule.
No, seventh is not there.
Advantage of
20 is not there in seventh. It's 2.
Yes.
But what I'm saying is it was in the contemplation, my lord. Both schedules were there. Both schedules were framed.
Suppose if it doesn't come, if fifth schedule is interpreted according to your interpretation of it, 20 taken together with 2 excludes counsel. But then seventh schedule is independent and it does not deliberately.
My lord, it's identical. My lord, word for word, some have been taken out.
That
That's
is
all.
exactly what we are saying, Mr. Mukherjee. This may be a double-edged sword for you because it's identical otherwise, but 20 is omitted. So therefore, whether seventh schedule, crucifies you.
Yes, my lord, my
Yes,
lord.
20 is not there in seventh schedule.
Yes.
So therefore, this argument that there is another provision, we'll have to think of
Yes,
that.
my lord. Because, my lord, the way I look at it, my lord, on affiliate aspect, I will address your lordship, my lord.
That's different.
Because if I get out on that, my lord, even the interpretations ought to be given, my lord, is
Yes,
yes, my lord, it
irrelevant.
goes out.
Irrelevant.
Goes out. Because, my lord, when we give that interpretation, my lord, we also have to examine, my lord, what was then the need, my lord, to incorporate in 2024,
Yes.
my lord, the explanation, when it is not clarificatory
Yes.
or not said to be
There are
clarified.
several unhappy aspects in this legislation, but whether we can look into that unhappiness,
No. What I'm saying is, my lord, if it's
For
taken
example,
from
constructive res judicata, there is nothing for foreign awards, even for domestic awards. No provision for constructive res judicata. There are several other things also. And even the schedule, you see, fifth schedule says B instead of A. That error has not been corrected till date. Unnecessary. Should have been corrected.
my lord, there was once a bill which was passed, my lord, a financial, my lord, matter, my lord, where instead of rupees, my lord, it was pound sterling in the schedule.
Probably it was meant by pound. It was meant a pound of flesh. Taking
So,
Q from
it had to
Shylock.
be Shylock.
Shylock's Q. Anyway, so
Because,
this
my
is-
lord, the classical drafts person now, my lord, is missing. My lord, in my lord, our my lord, legal departments.
absolutely,
So,
which is very evident from the
Yeah.
half copy pastes also.
yes.
Now, suppose section 19 of the Act precludes CPC and Arbitration Act. UNCITRAL model, that preclusion is not there. But we preclude very well, our legislature intended. But then 35 gives finality. So, by virtue of that fundamental principle, res judicata is applicable, but constructive res judicata is not. Order to rule 2 is not. There are many aspects, but let us not go on these. We are deviating from our topic.
Yes.
So therefore, now you'll come to affiliate probably.
No, my lord, my lord, this currently represents,
Currently, yes, that
my
also.
lord, I am, my lord, on that as well. But, my lord, whether, my lord, this includes, my lord, in appearance in one matter.
You can answer that, Mr. Mukherjee, because we have 4 minutes left today.
Yes.
So you can answer that aspect of the matter later and deal with affiliate.
Yes.
Or whichever.
Yes. So, my lord,
give that answer, but whenever you
yes.
The next week also you can do it.
Your lordship's taking the matter next week, my lord, on Wednesdays, I presume.
Yes. Wednesday we have some problem.
No, my lord, I just need a time accommodation. That's all, my lord.
If it's necessary, we'll.
Yes, because, my lord, committed elsewhere.
Oh.
My lord, I thought I'd conclude today, my lord, but I did not, my lord. So, my lord, no, I'll come, my lord. Kindly don't adjourn it. My lord, on Wednesday, I'll finish. I might just need a time accommodation, my lord.
Only one request from my side. I am
have some
available the
difficult-
whole of November and December except for that one Wednesday of 26th because I've got a part heard matter in Supreme Court on 26th.
No, you are available for whole of November
I'm-
except 26.
Yes, I'm saying that
My lord,
please
I'll
accommodate
conclude.
me on 26. If your lordships can accommodate me on 26, that's what I'm asking, requesting for.
My lord, I'll conclude on 26. My learned friend
That
can
be
come.
done.
So,
He'll-
your lordship then
So
permit
Mukherjee
me to
will
my lords, argue on the 3rd then thereafter.
Yes, absolutely. No
So-
difficulty.
Correct.
He'll
So
conclude.
26, I may be kindly dispensed.
No difficulty. Someone will be there.
Yes,
He'll
and I can
Mukherjee will
join perhaps
conclude and he'll
virtually.
be there.
I can perhaps join virtually and take notes, but I may not be able to travel on the 26th.
You can also appear virtually. We have no.
No, 3rd, my lords, I like to come. Since I've been coming here, so
Yes.
I'll come on the 3rd. So I'm so deeply
My lord, my learned friend, my lord, has followed my advice in getting out of a law firm. My lord, I told him he must argue, and because I found him very competent, and I felt that we must have good people arguing matters. He's getting a few opportunities now, my lord, in the Supreme Court.
Thank
So
God
I've-
you have done that.
No, I've done it to lots of
Mukherjee is
people.
very, very kind. I mean,
My lord, during COVID, my lord, we had discussions, my lord, because they were all, my lord, briefing me in the Tata matter, my lord.
He would be wasted. I mean, wasted. We use a good counsel then.
so deeply obliged.
There are a couple of others also are going to be leaving, my lord.
Your contribution to society.
That's the way I look at it, my lord. It's important to have people who
You have to
will
give back.
work hard, and my lord, I'm doing it.
Exactly.
My lord, I
Somebody comes and when he leaves, in between, there should be a mark in a different sense.
Yes.
That there should be a change
yes,
in the system.
my lord, I was castigated, my lord, by several seniors of this High Court when I started the practice of remunerating juniors.
Because they would be
No,
insecure.
I have a selection system also.
Achha.
That, my lord, anybody comes and says, I want to be a junior. No, we'll see what you.
You take an interview or something like
I do.
Achha. Oh,
I do.
absolutely.
That I don't want ultimately that because I think this chamber junior relationship is very sacrosanct.
Absolutely.
So I don't want wrong people in there.
True. Very correct.
That's the only
Very correct.
place where I have that. But once the entry is achieved, then anything under the sun, any difficulty,
You'll
they're
defend.
free to consult me and my family. That's how I open it up.
Gurukul, in the true sense.
It just, and it's good to be up to date with younger minds also.
Yes, always. Always. Mr.
So, which I was very fortunate to have with all my seniors, except that it went into very late at night with one of them, which wasn't easy. ठीक है. So 10:30 this will not.
So heard in part for further hearing on November 26, 2025. We'll hear Mr. Mukherjee. If he concludes, then we'll keep it on the next Wednesday.
Grateful.
My lord.
ঢুকে যাবে হ্যাঁ আগের নোটস গুলো দেখে নিয়ে একটু কোথায় আছে এরকম নোটস সেগুলো
Item number 17, 18, my learned senior friend is on the other side. It's a David versus Goliath fight, although ITC better, sir. But if the injunction order is sustaining from June, 20th of June, Lordship, if some precedence on some day could be given.
we cannot
Because
give any
Mr.
precedence to any
Mukherjee's
particular. All the
availability-
matters are important to us, so
I
no
bow
precedence.
down, my lord.
No precedence.
So baje hoye mention karo na.
Yes.
May I have lordship's limit to move this appeal, my lord, without certified copy. The order was passed yesterday, my lord.
Leave is granted.
Can it be taken up day after tomorrow?
What is this? The second appeal?
No, injunction, refusal of injunction order, my
Yes, tomorrow it will appear.
lord. Day after, my lord. Mr. Bhattacharya is leading.
Day after, very well. Oh, day after we have we sit singly. Monday. Yes.
My lord, two applications, my lord.
Yes.
Grateful.
My lord,
for release.
Yes.
may I be permitted to mention, my lord, this is a review application, my lord.
Yes, yes.
The
Review.
application is from the order of your lordship's order and Justice Uday Kumar, my lord.
Hand over the slip whenever you sit singly, we can arrange. Justice Uday Kumar সঙ্গে ওটা নিয়ে আসো। আলাদা করে ক্লাব করে রেখে দিও যে যখন একসঙ্গে কয়েকটা ম্যাটার এসে গেলে একটা ডেট ফিক্স করে বসে
FAT 487 of 2025.
What application?
Application.
Application
First
or hearing? No, hearing we are not taking it. Yes.
This is an application connected to item 5 of today's list.
Please hand it. Item 5 of today's list.
I'll hand over the slip when the matter is called. Because the two applications have to be.
You'll be asking for time then.
Item 5, I am
Yes, because-
appearing for the added respond, my lord,
It
to
should
be
be
added.
better if the two.
What is this application for?
It is against the grant of an administrative injunction.
So application is for?
Stay.
My lord, we would be also praying. We have obtained an order of injunction in a separate suit filed by us.
This is the subject matter.
They have challenged that in separate appeal. Now, my lord, here we are intervening in their appeal, saying that we are enjoying an order of injunction and they are praying injunction here. So, my lord, unless that is heard together,
The two
one
Give that
injunction,
appeal number and this application both will appear together on Monday.
Monday.
Yes. And
Item
because-
number 5, then, my lord, splits over.
Item number 5 will appear on Monday along with your other appeal.
Their
Hand over this slip, please. এটা 5 এর সঙ্গে আসবে and you give us slip regarding the other item number.
other number. This is the other number, and
This is the
5 is,
other
my lord, on list.
5 is there.
Oh, acha, this application is regarding the other appeal.
Other.
Very well.
And, my lord, we have a review also, my lord, that
Acha,
also
keep the slip with you. Didin একটু.
Yeah, that will be better.
Let it be called and we'll pass an order. We'll pass a formal order.
Application.
Application is. Call on the bill. You mentioned can we do? Mention कुछ for withdrawal बोले? For withdrawal. हाँ. Withdrawal
withdrawal, my lord. There's a letter.
without leave.
My lord.
Without leave to sue afresh. Without leave to sue afresh.
Yes, my lord. As my lord, they have, my lord, settled.
Learned counsel for the appellant submits that the parties have settled the matter and as such, the appellants seek to withdraw the appeal. Written instruction in that regard is handed over in court and kept on record. Accordingly, SAT number 248 of 2023, along with CAN 1 of 2024, are dismissed as withdrawn without any orders to cost.
Grateful. Item number 2, my lord.
Yes.
My lord, before your lordship, this matter, my lord, I have received the papers yesterday, my lord. Your lordship,
You have mentioned the matter.
no, my lord,
I mentioned.
yes, my lord. Well, only, yes. Well, I was just referring that order, my lord. There is an order, my lord. If your lordship kindly reads, my lord.
This is against eviction.
No. Well, these are
What
declared
case will continue in the court below?
Execution.
What sort of a deal?
recovery of possession, my lord.
You are
Declared,
asking for time to deliver granting time?
Not-
This order is already there.
no, my lord, what I was paying, my lord.
The second appeal was heard for this honorable, the
No.
coordinate bench of your law.
Then what happens?
And the honorable coordinate bench also view that the appellant, they are not going to admit the appeal. And the
No.
appellant sought for some time so that he
No.
can vacate the
My lord,
premise.
subject to correction.
And notice was issued upon.
But this matter was near
Oh,
not.
wait.
Yes.
Oh. No. We
Well,
cannot.
may I, my lord?
Question of admission. hearing up.
Well, may I, my lord, subject to correction, my lord, but probably this appeal is neither admitted, neither dismissed, my lord. Well, because my lordship will kindly seize, my lord, those.
View was clearly explained. One bench
Well,
is taken,
view
we
was-
won't deviate from that.
Well, if your lordship, my lord, grants me, my lord, an opportunity, my lord, so that I can address, my lord, if substantial questions of law is there. Because this is nothing, it's not dismissed, neither admitted. In the midst, even I have gotten,
No, court expressed his view,
expressed
not
his view,
inclined to admit the appeal, as
yes,
there is no substantial question of law
question of
involved.
only because
That's an adjudication. No substantial question of law.
I would be humbly praying, if
And
as
on
this
your
is-
prayer, this is sharp practice, Mr. Chakravarti.
no, I
This
should
is
be very,
absolutely sharp practice.
Malab,
The council submitted that they may be permitted to remain in occupation. Definitely not.
at that point of time, I did not appear in
Yes,
this
if you
manner.
want to give an undertaking, we are permitting you. No. Whoever appeared, you cannot change counsel and change stands.
I'm not changing the
It would have
stand,
been
but-
dismissed on that date unless you prayed.
No, only one prayer before Lordship, because this order is on 2024.
Yes, are you ready with the undertaking?
Then I have to come back with the instruction.
You should have come with that
No,
instruction.
there is another problem. I should be very candid with your Lordship, the advocate on record who was conducting the case, she has not given the no objection
Then
certificate.
you don't have any locus standi to appeal.
Yes, I have the letter and the
Letter won't do. If you
because
don't have a
the client has already sent the letter, so that it's something. If your Lordship gives me a week's adjournment, I can.
Why did you mention the matter at all?
The mentioning because the date is on 18th. Yes,
They're going to demolish.
They are going to demolish. I was in possession since last 40 years. The buildings are there. So for that it has been mentioned. So only prayer is that if your Lordship takes it on next week, I'll come. Either I have the instruction or I don't have.
Learned counsel for the appellant seeks an adjournment for a week and submits that the matter ought to be heard under Order 41 Rule 11 of the Code of Civil Procedure. Full stop, next para. However, learned counsel for the respondents indicates that by an order dated November 22, 2024, a coordinate bench had, in categorical terms, expressed its views that though the said court was not inclined to admit the appeal, as there is no substantial question of law involved, only on the prayer of learned counsel for the appellant that they may be permitted to remain in occupation for a brief period of time, a notice was directed to be given to the respondent. Full stop, next para. For the sake of judicial propriety and borrowing the principle of committee, COMITY, committee of courts, we are unable to deviate from such stand and, at this juncture, post the appeal for hearing under Order 41 Rule 11 of the Code of Civil Procedure afresh. Full stop, next para. It is evident from the order dated November 22, 2024 that the appeal was on the verge of being dismissed under Order 41 Rule 11 and the coordinate bench expressed its specific opinion that no substantial question of law was involved and the said bench was not inclined to admit the appeal. Full stop. As such, the appeal was virtually dismissed on the said date itself, but for the appellant's prayer for some time to remain in occupation. Full stop. Next para. We deprecate strongly the sharp practice being adopted by the appellants by seeking a fresh hearing under Order 41 Rule 11 of the Code of Civil Procedure, of which there is no scope at all. Full stop. Learned counsel appearing today for the appellants candidly submits that he does not have any, he has not yet obtained any no objection certificate from the earlier learned advocate to the present learned advocate who is appearing for the appellants. Full stop. Hence, strictly speaking, we ought to have dismissed the appeal outright. Full stop. However, for the sake of justice, we postpone the matter till November 24, 2025, when it will be listed under the heading to be mentioned for the limited purpose of ascertaining whether the appellants is agreeable to file an undertaking for leaving the suit property within a limited period. Full stop. However, we reiterate the observation made by the division bench, the coordinate bench on December 17, 2024 to the effect that pendency of the second appeal at the admission stage shall not prevent the trial court in proceeding with the connected execution case in accordance with law. যারা ডিসমিস করতে গেছিল ওর প্রেয়ারে sharp practice.
Item number 3, I beg to appear for the appellant, my lord. My lord, I generally don't pray this, my lord. Can it be taken up on
No,
Monday?
no, after mentioning the matter for inclusion, we cannot.
My lord, I've been led by Mr. Shantan Boshu, my lord.
Then it goes out of the list, sorry.
Uh,
Either remove the matter, you, on
my-
your mentioning it has
My
come.
lord, it is, my lord, on my mentioning, my lord, on my
Then
mention.
we just,
And there is an application for condonation of delay, my lord. There is a delay of 17 days, my lord.
served a copy.
Yes, my lord, I've served a copy and
17 days we are condoning and taking up the order for turn, the appeal under order for turn.
my lord,
What is the ground for delay?
my lord, delay, my lord, there was a delay because the appellant was sick when he's old when he's a senior citizen. So that is the ground for the delay, my lord. This delay has been
Senior citizen by 69 years, that means that you will be entitled to file the appeal late.
Definitely not, my
Ground
lord.
at all.
Definitely not, my lord. The ground is mentioned in paragraph number 4, my lord. There was a delay in preparing the appeal also, my lord. I should take it upon myself as well. There's a delay in preparing paragraph number 4 and 5, my lord, of the application and can 1.
In paragraph numbers 4 and 5 of the condonation application, it has been stated that since some time was taken for preparing the appeal and drafting the memorandum, comma, the appeal was filed after a delay of about 17 days. Full stop. Upon hearing learned counsel, we find sufficient substance in the sufficient justification for the delay. Accordingly, can 1 of 2025 is allowed on contest, thereby condoning the delay in preferring FMAT 375 of 2025. No order is to cost. Affidavit of service filed to be kept on record. Yes, what is the matter?
My lord, the matter is that the appellant before your lordship is an author, my lord. He has written 4 books, which the respondent plaintiff has been by way of an agreement they have been given to publish those books, my lord. Thereafter, my lord, the appellant used to receive the royalty, my lord. Then there was a dispute between them. The appellant, by way of a letter, had cancelled that agreement between the publication right has been cancelled. They challenged that publication right before the learned court below.
Publication right has been cancelled by you.
Yes, my lord.
There was a written agreement previously.
Yes, my lord. Those are annexed with you. Those are on record, my lord. Then that was cancelled, and they have
You
challenged.
cancelled because they were not paying you the royalty.
Yes, my lord.
There was a
For
provision
4
in the-
years, my lord.
There was a provision in the
Yes, my lord.
original.
But that is not the case before your lordship at this moment, my lord. The fact is that then they have filed an application under Order 39 Rule 1-2, my lord.
What is the suit for?
They suit for declaration and permanent injunction. They were
Declaration.
declaration. They are declaring that these cancellation letters served by us to be null and void, and permanently injuncting us to give any third party right, creating any third party right. Thereafter, my lord, what has happened? They have got an order of injunction, my lord, whereby they have given the right to publish the book along with upon payment of the regular royalty and giving statement of accounts, my lord. We have challenged this order before your lordship by on a coordinate bench, my lord, has asked them that to pay an ad hoc amount of rupees 25,000, which they have paid, and to also directed them to quarterly submit the statements of account, which they did not do, my lord. They did not do
25,000. They did not pay.
No, the 25,000 they have paid, but they have thereafter the quarterly statement, submission of statement of accounts of the books, my lord, that has been sold was not submitted before the court below, neither to the appellant before lordship. Then we came before your lordship, my lord. My lord had the opportunity to take up that matter, my lord. If I may take your lordship to that order.
That was against the ad interim injunction.
Yes, my lord. Not ad interim injunction, my lord. There was a default clause. They default.
Previous appeal was against the ad interim injunction.
Yes, my lord. Not ad interim, my lord. Interim injunction, my lord. Absolute. After finally hearing the Order 39 Rule 1-2. Not the ad interim injunction, my lord.
But 39-4 has been filed after contested hearing.
Yes, my lord, because my lord had directed us to file. My lord given us
your undue hardship.
Yes, my lord. My ground was that my lord directed them to submit the statement of account as well as give me the royalty on a regular basis. They have not doing though. My lord, whilst taking up the application, my lord has granted me a liberty to file an application under Order 39 Rule 4.
What is that order?
Page number 148 of the my lord's the application, my lord. Volume করা আছে কি? Link করা আছে কি? May I read it for you, lordship?
Not the entire thing. Let us see just.
And my lord, kindly come to pay.
No, they were not directed to pay royalty at the first instance.
It was made clear by your lordship, and my lordship, as they were defaulted, my
No,
lord.
no, the trial court had
Well,
stated.
may I read it from paragraph 17 for my
So
lord?
para 2 says that the plaintiff's that the initial and injunction order was obtained by the respondents to the effect that appellant shall not prevent the continuous publication of the books,
Yes, my lord.
subject to the rider that accounts would have to be furnished, not payments.
Yes. Then thereafter, when we challenged that order before the honorable
Yes,
court,
yes.
then at that point of an ad hoc payment was given, and also was directed that they will quarterly submit their account statement of accounts, my lord. And as they defaulted in that, by way of this can 2, we came before your lordship, and lordship has come.
One second. That previous appeal was against the final injunction order.
Yes, my lord.
So there an ad hoc amount of 25,000 was to be
Yes.
paid.
Yes.
Nothing else.
And also to submit the quarterly statement of accounts. They did not do so. My lord has observed that in
So
this.
quarterly statements have not been achieved.
My lord has categorically observed their conduct, my lord.
They had alleged that they tried to tender the royalty and all. Please read from para 13.
My lord, even if we proceed on the premise that the respondents' avowalments of tendering statements of account as per the affidavit in opposition are correct, we find that the direction of this court to file the quarterly accounts have not been complied with. The only 2 statements referred to in the affidavit in opposition are of the period between April 1st, 2022 and March 31st, 2023, and the period between December 1st, 2023 and July 31st, 2024. Hence, the quarterly statement between March 31st, 2023 and December 1st, 2023 and after July 31st, 2024 are not even pleaded to have been furnished by the respondents. That apart, the long gaps in filing the statements are violative of the direction of the coordinate bench to file quarterly accounts, which are by definition to be filed every 3 months. On the other aspect of the matter, the respondent are justified in arguing that this court has limited jurisdiction in view of the self-same issue having been decided by the learned trial judge by order number 17 dated June 12, 2020.
That was a different suit.
The same suit, my lord. Passed in title suit number 860 of 2022.
What was that order?
Order number title. Well, we had filed 151 application seeking that them to comply with implementation, but that was my lord. Before the state court, similar allegation of violation of the direction of this court were put forth by the present appellant, and the same was decided by the learned trial judge. Hence, the self-same issue cannot be re-agitated before this court in the disposed of appeal. That apart, since the liberty to approach this court was restricted to non-payment of the ad hoc amount, directed our hands are tied in the regard, as well as since the payment of rupees 25,000 was made by the respondents. However, even going by the observation of the trial court in the order dated June 12, 2023, the learned trial judge observed that although the statement of accounts having been supplied to the defendant, but not in the manner as desired by this court, it was further recorded in the order that the plaintiff, present respondent are required to comply with the direction of this court properly, or they may lose the liberty of publishing the books as laid down by the honorable court in the said order. Hence, a leeway has been left open by the learned trial judge in the order dated June 12, 2023, to the effect that in the event the direction to file quarterly accounts passed by this court are not complied with, the plaintiff's respondents herein may lose the liberty to publishing the books as per order of this court. Hence, on a comprehensive assessment of the materials, we find that the respondent have undoubtedly failed to comply with the component of the order of this court, disposing of the appeal whereby they were directed to file quarterly statement of accounts.
We just said that because you had approached us in the self-same dispose of appeal.
Yes.
On the basis of the liberty given by the court, because if they don't pay that amount, then you are to come.
My lord.
They paid the amount, therefore we said that we have limited jurisdiction.
Yes, my lord.
But we gave you liberty to. Yes, what about the quarterly? Why was it refused by the
My lord, kindly, the learned court below surprisingly felt that there was no change in circumstances and there is no undue hardship.
Yes, what do you say?
This order was passed in 151 application. That is the revisable order, not appealable.
39 not filed.
No.
Right, the nomenclature was 151. The nomenclature.
What is the prayer?
What is that? Kindly come to the application, my lord.
Yes.
Page number 156, my lord. The prayer is 159. Your petition is filing this application seeking for an order for
Yes,
vacating the
order
injunction.
Nomenclature is immaterial.
My lord.
Order is passed under 39.4.
And the court also has
Court also proceeded on the premise of
the
39.4. Yes. Why have you not given the accounts?
Yes, my lord.
We'll vacate your stay.
No, I have given my lord the accounts, my lord.
No.
Your lordship also, my lord, in court, my lord, your lordship check up, my lord, I filed my lord accounts, my lord, before.
No, we had observed that you have not violated the order.
But not sequentially, my lord, but give all the accounts.
Specific direction was that the
all accounts was given.
Have you annexed that 12th June order?
My lord.
12th June, which you have referred to in our para 16.
Filed affidavit, short affidavit, my lord, annexing my lord, all
Literal
the
affidavit. First, let us look at this.
all documents.
135.
I have given my lord all the accounts, my lord.
12th of June 2023 order.
My lord, unfortunately, it is not annexed.
You referred to that order.
Yes.
What was that order? The original injunction order?
No, my lord. That is not the original. Original
That was
injunction
passed on
order
what?
is, that is the original injunction order is at page number
So
105.
what is this? We have observed in para 16 of our order.
My lord.
That even going by the observations of the trial court in the order dated June 12th, 2020.
No, this was an application under 151 seeking implementation
on that
ground, my lord, that they are not submitting the quarterly statement, my lord.
In that order, it was recorded by the trial court itself, Mr. Mondal, that you are required to comply or you may lose the liberty of publishing the books as
I shall give them all.
You have not. You have not.
My lord, another thing I would like to point out with your lordship, the matter is currently at the stage of PH hearing, my lord. Every time they are seeking adjournment on the ground that they are going to give us inspection to the statement of account, we have all annexed all those letters, or they are going to sit for a settlement, and they are delaying.
This is an exit fixed in trial.
5th of January 2025, my lord. So it's 26, my lord.
Mr. Mondal will give you 1 week. We are admitting the appeal. We'll grant you 1 week's time to file an opposition, annexing all your the statement of accounts. Not only that, the receipts showing that you have when you have given those to them, and you will file a reply in 3 days. We'll take up the appeal and the application to
my lord. But in the meantime, if they are not restrained from
39.4 has been rejected.
My lord, I know, my lord. I was just
that would be beyond the scope of the appeal. The defendant in a suit filed by the respondent's publishers challenging the cancellation of a publishing agreement between the parties has preferred the present appeal. Next para. By the initially, a temporary injunction order was passed restraining the present appellant from preventing the respondent's publishers from continuing to publish the book authored by the appellant in terms of the agreement between the parties, subject to the respondents furnishing quarterly accounts as well as quarterly accounts. Next para. Upon a challenge having been preferred against the said order, a coordinate bench had disposed of the appeal by directing an ad hoc payment of rupees 25,000 by the respondents to the appellant, as well as directing the respondents to file quarterly statements of accounts in respect of the sales of the said book. Next para. A liberty was given by the coordinate bench for the appellant to approach this court in the event such amount was not paid by the respondents. Next para. Although the respondents made such payments, made such ad hoc payment, the quarterly statements were not furnished in time, leading the appellant to file an application in connection with the previous disposal of appeal, which application was adjudicated on January 7, 2025 by this court, thereby granting liberty to the appellant to approach the learned trial judge with a prayer for vacating the injunction granted to the plaintiff's respondents and or any further penal step against the respondents for non-furnishing of quarterly statements of accounts in respect of the royalty to the defendant/appellant. It was also kept open for the defendant petitioner therein within bracket present appellant, bracket close, to seek a further direction from the trial court directing the plaintiff's respondents to pay either a further ad hoc amount of royalty and or to regularly pay the royalty as well as to furnish quarterly accounts. You did not ask for royalty, you should have asked for royalty also.
We did not. We only sought
You-
for vacating of the
Anyway,
injunction.
pursuant thereto, an application, all the caption under section 151 of the Code of Civil Procedure, substantially under Order 39, Rule 4 of the Code of Civil Procedure was filed by the appellant for vacating the injunction order for non-furnishing of quarterly statements. Full stop. Next para. By the impugned order, the learned trial judge merely observed that there has been no change of circumstance and as such and that the injunction order does not cause undue hardship to the defendant and accordingly dismiss the said application for vacating. Full stop. Next para. Although learned counsel for the respondent takes a preliminary objection as to maintainability of the appeal on the ground that by the impugned order, an application under section 151 of the code was dismissed, since the power exercised by the court was under Order 39, Rule 4 of the code, which could not be governed merely by the caption of the application, we admit the appeal to be heard on the above questions and the grounds taken in the memorandum of appeal. Full stop. In view of the scope of the appeal being very short, we dispense with the trial court records and service of notice of the respondents, since the respondents are represented through the learned advocate. Full stop. The respondents shall file their affidavit in opposition to Can 1 of 20. What
one is minus
Can
section
2,
five.
Can 2 of 2025. Within a week, within November 26, 2025. Full stop. Reply, if any, shall be filed by December 1, 2025. The application shall next be listed on December 2, 2025, along with the appeal for being heard together. Full stop. It is made clear that although the matter shall be listed under the heading application, the appeal will be taken up for hearing along with the application.
One indulgence. We also prayed for restraining the plaintiff for publishing or selling the book in our application.
No, right now we won't grant that because that will be against the.
It was my duty to point it out before.
That will tantamount to allowing this appeal because you have sought for a vacating. If you grant that, that will be vacating.
Grateful, Lordship.
Suit for specific performance.
I am sure that the proposed added defendant notice has been given to me by your lordship's order.
Yes. My lord, in a suit for specific performance in relation.
You have filed an addition of party application? No.
No, not
Formal.
here, my lord. My lord, what had happened is I filed the suit. There was a caveat. So, my lord, I could not proceed with the injunction application.
Just pointing out.
Yes.
Arindam, last time they came and Arindam Banerjee, I think, was appearing.
Yes, Ms. Oja was there.
Yes.
Yes, carry on.
So, my lord, first day, my lord, show cause is the usual order. So that happened. The bank.
Sorry, the suit was filed for?
Specific performance of contract.
What sort of contract?
My lord, it's a contract for sale of 21 kathas of land at Mayfair Road.
You filed the suit?
I filed the suit.
Bank agreed.
Different number one, this is property owned by the bank, which they were using for their quarters, etc., officers' quarters.
You entered into an agreement with the bank.
With the bank for purchase of the property.
The bank entered into that agreement to sell their property?
Yes, with me. They had made a public tender. I had not participated through brokers. I had participated, given an offer, negotiations, agreement fructified. I paid them a crore odd. And then, my lord, we did due diligence. In the meantime, my lord, in the middle of due diligence, it was discovered that two parts to the property. The property which they are selling is in front. There's a housing society at the back. Not a real estate project. Now, there was no formal deed of partition, as a result of which the people at the back would have undivided right in the land here. So that had to be done. So we told them we'll get that done, etc. We were negotiating on that. Suddenly one day they refund. So I go and file a suit. So their claim was, I'll sell on as is where is. We said it's not possible. This is, and you have entered into an agreement with me. One day money returned, and which I haven't encashed. I file a suit for specific performance. In the written objection, there is, my lord, no whisper of any
And
sale.
if you file a suit for specific performance, Mr. Chaudhary, as is where is in the agreement, then you have to take it as is
No.
where is and then
No,
have the
now
partition with them.
that is the
You
beauty
purchase
of
the-
it. They agreed subsequently. There's no written agreement. Agreement is recorded in 5 documents. May I show your lordship the document? Correspondence.
So they
I'll show
agreed
your
to-
lordship the document.
They agreed to what?
They agreed to sale based on, my lord, separation of the property by boundary wall.
At your base, you will be doing that.
And they would pay me 10 lakhs for that. But that is only possible when this would be done. So to that extent, they waived the clause. And there was also a clause for time, which they extended and waived. And it became, my lord, reasonable time. Now, suit filed, WO filed, no whisper of sale. Thereafter, in the written statement which is filed, there is one sentence: we've sold the property. Just one sentence. We will not get the written statement, start say a search, etc. Now we find that they are demolishing the property. So the purchasers. So we file an application under Order 22 Rule
They're
10.
another third party, not the housing society people.
No. Third party purchaser. So they have purchased. Now
demolishing what? There was
the existing structure on the property which we were
there was
to
a
buy.
structure also, not
Yes,
a land.
yes. This was their officers' quarters, my lord. So they've started demolition. So we filed section 94 for an injunction, and we filed Order 20.
They purchased when, according to them,
They purchased on
September 24th.
So during pendency of the suit.
After the suit, list pendant sale. My lord, it's on 11th of September
You
24.
wanted another injunction on them now.
On them and on him. Really, him is meaningless. On them and Order 22 Rule 10, so that they can be, they have to be first implemented. Now that's, my lord, pending. If your lordship sees the order, my lord, perhaps it is not correct.
Why didn't you add in the first place, Mr. Mukherjee's? Oh, their Order 20 Rule
This is
10.
after.
That has been rejected, Order 20 Rule 10.
No, my lord, but some observations made which are very damaging. My lord, please, my lord, look at the memorandum of appeal.
Yes.
First page. Please see the last paragraph. It is also significantly relevant to mention here at this stage, while the suit is running in contesting format, there is hardly any scope to hear the matter in respect of impleading party without giving reasonable opportunity of being heard to the defendant bank. That's wrong. And so far as the question of status of the suit property is concerned, it is prima facie admitted position of fact that the plaintiff has filed the instant suit seeking legal enforcement of one agreement for sale. And this is, my lord, the difficulty. And unless any decision is arrived at as to the enforcement of such agreement, there cannot be any conclusion to be made by this court that the plaintiff has acquired any right, title, and interest over the suit property. And it is well settled that there is no legal bar which put an embargo upon any litigating party to transfer property under litigation. However, it is also well settled that there is no necessity in all cases to implead any subsequent purchaser of the suit property, as the same may lead to create unnecessary legal intricacies. And it is also well settled that the result of the suit is also binding upon such purchaser as per section 52 of the Transfer of Property Act. Moreover, this court is also of the opinion that relief of injunction is in the nature of equitable relief, and hence this court does not find it justified and proper to exercise its judicial discretion in the instant matter to entertain the prayer made under Order 22 Rule 10, read with Order 1 Rule 10(2) of CPC, without giving reasonable opportunity of being heard to the contesting defendant party of this suit. And unless such application is considered by this court, This court also does not find any justification to consider the prayer made on behalf of plaintiff at this stage without service of notice.
So this is no conclusive order, but deemed refusal of the ad interim prayer.
Deemed refusal ad interim prayer. Now, my lord, that's why in the appeal I have given notice to the purchaser. Now, my lord, this is
Injunction is sought against both.
against. I'll just check, my lord, once.
This is the bank
Should not make a mistake. My lord, page 428.
Against whom?
Order restraining. No, purchaser also.
Purchaser also.
Oh, Mr. Mukherjee is the purchaser.
427.
434 is the prayer. Starts from, my lord, 428. Now, my lord, if the learned court below is of the opinion that in all cases a transferee pendent
Only against Mr. Mukherjee's clients, not against the bank.
Yes. So if the transfer, he's demolishing. Now, I couldn't get an injunction because my original injunction application is also being heard. It is in the present continuous tense. But, my lord, I'm in a hapless condition. I could not get an order of injunction. So my merits couldn't be decided prima facie. Now he's transferred. Now against the transferee, learned judge says that the original defendant must be heard. In all cases, substitution, I'm sorry, Order 22 Rule 10 need not be allowed, even though there is a transfer of the suit property.
Let us hear him. Yes, first Mr. Mukherjee, then you. You are enjoying the fun.
The one thing is that this 22 Rule 10 and the application under Section 94 for an injunction on Mr. Mukherjee's client were both sought to be moved ex parte.
Yes, we see that.
Both were moved ex parte when I was already on board. Not even a copy of the put up was given to me. So according to them, court should have ex parte allowed 22 Rule 10 and then ex parte injuncted. So there are two orders that they sought. The non-allowing of 22 Rule 10 frustrates his prayer for ex parte injunction because injunctions are generally granted in personam. Therefore, perhaps, my lords have admitted this under Order 41 Rule 11, but perhaps this...
We have admitted. We will admit if you have not.
No, Order 41 Rule 11, subject to my lord's correction, my lord, perhaps...
Only for reason of our absence, it could not be heard on the 2 days. Equitable distribution of blame. One day for me, one day for him.
I'm not on that. I'm saying his motion was ex parte for the 22 Rule 10. The question is whether the court erred in directing him to serve a copy on the contesting defendant of the 22 Rule 10 and then move it. That's the
we can consider only the question whether the court erred in not granting ad interim
injunction against a person who is not a party.
Yes, who was not a party. But who was sought to be made a party.
Who was sought to be made a party without completing the process. Because no copy was served on me. I may have a stand or two to say. And it may not be inflexibly true that everyone should automatically...
You're physically trying to...
Yes. Intimidate? I'm sorry.
Not intimidate, assault Mr. Mukherjee. He has moved away, just
I'm very close to him. So that's why he stays to the left generally, I have seen.
Yes, Mr. Mukherjee, what is it?
My lord, number one, my lord, this appeal is from the application under Section 94, Order 39, Rule 1-2. Not from Order 1, Rule 10, Order 22, Rule 10. They could not have filed. It's not an appealable order. Therefore, my lord, your lordship will see also that your lordship has rightly, on the first occasion, only asked us to give notice and not made us a party. We couldn't have made a party here at all. What was refused, my lord, since the order is not appealable, they could not have come before your lordship to add us as a party at all here. Order 1, Rule 10, first of all, it was not a refusal order or granting. It was an Order 1, Rule 10 application, and order passed in Order 1, Rule 10 or Order 22, Rule 10. Where, my lord, at that stage, I was not added as a party. The order records, if your lordship again goes back to the order, my lord, the last two paragraphs, at that stage, we were not made a party. We could have been made a party, but nevertheless, that order is not appealable. That is why, rightly, Mr. Chaudhary has not preferred an appeal from that part of those applications. There were two applications filed. Your lordship,
Mukherjee,
yes, my lord. That's a technical point. But your lordship, my lord, I'm saying
answered our question.
It's a technical point. That's the first point, my lord. Second, my lord, the suit I find, my lord, is also not a suit is not maintainable at all. This is on merit.
Why do you say that?
Your lordship will go take the plaint once, my lord. Plaint is at page 47. Your Lordship takes paragraph 47 of the plaint at page 60.
Yes.
My learned friend proceeds on the basis that the agreement was terminated. Rightly, wrongly, the agreement was terminated. Surprisingly, on 10 January, the defendant has wrongly terminated the agreement between the parties by email. Para 48, the plaintiff states that the plaintiff has always been ready and willing to perform the agreement and has not acted in breach of any term. The defendant has, however, wrongly repudiated the agreement, which was wrongful refusal or repudiation the plaintiff has not accepted. The Lordship will kindly take the prayers at page 62. There is only a decree for specific performance. There is no prayer seeking declaration that the termination was wrongful. Now, the Supreme Court, rightly or wrongly, right now has
unilateral termination.
Yes, my lord. Supreme Court has recently held, my lord, that even if it is a unilateral termination, without a prayer seeking declaration that the termination was wrongful, a suit for specific performance is not maintainable. Itana 2025. 2025 3 SCC 5. Justice Dipankar Dutta. He's held it twice in 2 months. Your Lordship, this is the first one. Your Lordship takes if the Lordship
Give the citation to him, he can find out.
2025 3 SCC 513, I will hand it over to him. If your Lordship takes paragraph 22. Oh yeah, I have it. Lordship takes para 22 and 41. Absent a prayer for declaratory relief that termination of an agreement is bad in law, whether a suit for specific performance is maintainable. Well, in 2015, there was a judgment of IS Sikandar, and there were some contradictory orders which were passed. Then, my lord, if your now Lordship takes page para 41, where his Lordship has clarified. A comprehensive reading of the two decisions, that is, my lord, A. Kanthamani and IS Sikandar, reveals that in a fact scenario where the vendor unilaterally cancels an agreement for sale, as in our case,
yes,
the vendee who is seeking specific performance of such a contract agreement ought to seek declaratory relief to the effect that the cancellation is bad and not binding on the vendee. This is because an agreement which has been cancelled would be rendered non-existent in the eye of law, and such a non-existent agreement could not possibly be enforced before a court of law. Both the decisions above are unanimous in approval of such legal principle. However, as clarified in Kanthamani, it is imperative that an issue be framed with respect to maintainability of the suit before the court at first instance, and it is only when a finding on the issue of maintainability is rendered by the trial court that the same can be examined by the first and second appellate court. In other words, if maintainability is. So, my lord, after this, his Lordship has passed another judgment, my lord. If your Lordship takes 2025 SCC online SC 723. Well, para 24 to 27. Well, his Lordship was a party to this judgment, but the judgment has been passed by another judge. His Lordship. The Lordship takes para 24. Well, same issue. Well, your Lordship will find, my lord, at para 25, my lord, again, IS Sikandar, Kanthamani is quoted, and R. Kandaswamy. Kandaswamy is the one which I had cited. Well, that the same paragraphs are quoted. And then if your Lordship takes, my lord, paragraph 26 and 27. Since in the present case, the seller had issued a letter dated so-and-so, cancelling the agreement to sell prior to the institution of the suit, the same constitutes a jurisdiction fact as till the cancellation is set aside, the respondent is not entitled to relief of specific performance. Consequently, this court is of the opinion that absent a prayer for declaratory relief, that termination, cancellation of agreement is bad in law, a suit for specific performance is not maintainable. This is the judgment which has been passed. All I'm saying, this is the law. Now, my lord, that's why the suit itself is not maintainable. Secondly, your lordship will now take on merits. I'm sure Mr. Banerjee will show. But if your lordship takes the merits, the plaint, what is the case which has been made out? Paragraph 8 onwards.
Mr. Mukherjee, in their plaint, they've admitted that he terminated the
paragraph. That's why I showed my para 47, 48 of the plaint. He proceeds on the basis there is a termination, wrongful. That's why I wanted to show that. Now, if your lordship takes paragraph 8 onwards, my lord,
yes,
it's letters. There is no agreement for sale per se. There is no one document which is an agreement for sale. They are saying paragraph 8 to paragraph 14.
Isn't that permissible, Mr.
It's permissible. So it is an agreement for sale of an immovable property. It is unstamped, unregistered. It is unstamped, unregistered. And finally, and most importantly,
no, unregistered in a suit for specific performance, the Registration Act says that it can be done. Registration Act 49.
Yes, my lord. But if your lordship is
and stamped
kind of
it can be impounded.
Yes, my lord. It has to. For my lord, Justice Bhattacharya, Justice Bhaskar Bhattacharya's judgment is there, my lord. It has to be impounded. Money has to be deposited in the meantime. After that, whether the suit is entertained or not. But that I'm not going into that. I'm saying it's unstamped, unregistered, and most importantly, your lordship will see, my lord, the documents which my learned friend is seeking specific performance of.
Yes.
Page 62, my lord, there are 6 letters. 19th December, 23rd December, 28th December, 3rd January, 11th January, and 18th March 2023. Your lordship will come straight to that 18th March 2023 letter, my lord. This is the last document which he is seeking performance of, and he has said there was waiver of the timeline. So the waiver ought to have been within this 18th March letter. Your lordship will kindly take this 18th March letter. This is obviously on merits, and that Mr. Banerjee should be arguing more. But if your lordship takes it, my lord, once, 18th March letter is at page 95. This is the bank's letter.
Yes.
Firstly, we acknowledge receipt of the letter dated 23rd February by MR Realtors. MR Realtors is my learned friend. However, we do not entirely agree to the 3 points. We are also in receipt of the mail sent by you on 9th March post your engagement with MR Realtors pertaining to expediting approvals from authorities for demarcation of the land. Based on our discussion yesterday at our home, we confirm the following. MR Realtors will expedite approval or demarcation of land. Bank will support in documentation and paperwork. We are approving expenditure reimbursement of up to 8 lakhs. This will be payable by the bank post registration. We understand post getting demarcation approval, clear title will be established. Construction of wall will be done by MR Realtor as part of refurbishment of the premises. 2. We expect MR Realtor pay 50% this month and balance on registration. We desire the registration be concluded by between 30th April and 7th May 2023. We have factored the time for obtaining approvals and registration formalities. We are positive that MR Realtors will be able to close the deal in expected timelines. In case of any situation where the transaction isn't concluded and both parties mutually agree to cancel the sale, bank will refund the entire amount received from MR Realtor. Bank will then be free to enter into the market again for sale of the property with no objection for MR Realtor. So, my lord, there's a timeline which is maximum given 30th April to 7th April 2023. The agreement has been terminated, I find, my lord, in January 2024. So, beyond the timeline. Payment also, from what I find, well, it's a 35 crore contract. Let me finish, man. Let me finish.
I think I'll concede, Millard. Just on this first point, Millard, please see that sentence I marked.
Judgment
That is.
You're sure you'll concede? Think twice. It's like KBC sort of scenario. Think twice.
But that is.
You can take a helpline also.
May I reconsider for 1 day?
Reconsider. There are various aspects to it. This is distinguishable. Come back tomorrow. But Mr. Mukherjee has argued very well.
Yes.
And Mr. Banerjee did not get a chance, in all fairness.
Excellent. Well, tomorrow. I
Come back tomorrow. Come back tomorrow. Think in different lines.
Well, this is a judgment which is there. That's all.
No, this judgment is definitely there. It's binding on us.
Yes.
But you also, Mr. Mukherjee, think.
That's why I started by saying there is a judgment on this.
No,
point,
there are
right?
two judgments. These are fully binding on us. But please think out of the box.
My advocate on record has some problem tomorrow. He is saying.
But
possible to keep
day after tomorrow, we sit singly. Can you stay your hands on demolition till Monday?
That's the most important point.
You already
No, my learned friend has not been instructed properly. It is on record. There is no demolition whatsoever. I've done renovation. I'm living there.
Don't do anything till Monday.
On a sanction plan,
whatever you have done till date,
don't
do anything else. Anything
there's no demolition that is happening. It is on record. My sanction plan for renovation, for refurbishment is there on record. I put it on record. He had filed a criminal case against me. I had filed a written objection.
Whatever, just don't do anything till yes, whatever is there is there.
Yes, ma'am.
Don't do anything different till Monday.
Till Monday. Renovation korchilam. I'm living there. Huh?
কি দেখাচ্ছ?
What is the proposition here?
Yeah, it depends. You can't say that cancellation has to be challenged in So
no, there are
even other ways, but this is
there's a recent judgment after that recently. I am not aware of it, Malak. It's
I think it first principles.
No, give Mr. Chaudhary this judgment.
What we learned is this.
देखो ना, first principles are that absolutely not necessary.
If you terminate an agreement that does not.
There's a judgment of 10th November.
The moment to super specific performance, unilateral termination has happened, that's bad, and you can state away super specific.
Addition also, Mr. Banerjee, you have several things to overcome because from Muktoke Shida onwards, 88 Calcutta Division Bench, page 25. Lease pendants 52 is not a bar to grant of injunction. And in a specifically fact, all the specific performance suit all the more because bona fide purchaser will, and other aspects are there also. I mean.
The board essentially discussions it shouldn't have, but the basic point was they tried to move it expert. You should have put me on notice and put.
And
22 rule 10 done, and then gotten an expert order of injunction against.
I find that matter was again on 17th of November. It was.
You are present. You are present before us. Don't forget that. So we take that into consideration. We are giving you sufficient cues. And please, all of you think in regarding Justice Dotto's judgments, think in the line of Contract Act, the later portions of the Contract Act. We'll give you one clue after section say 180, 190. After that.
The contract, my lord, is never discharged by any unilateral act.
Don't do it extempore, just go through the contract.
Give us the section without saying.
Sections 202 204.
Interest.
202 204.
Interest.
Go through that. Dhorun.
I've got the hint. But I also.
During hearing, it transpires that certain. What? Now, regarding renovation, where have you put it on record?
I've put it. Your Lordship will kindly see. Their allegation only is that there is demolition. That's why they're asking for an injunction. That is the only allegation. And your Lordship will see, my lord, page. They had filed a criminal case. Your Lordship will give me one moment.
Now, during arguments, it transpires that certain judgments have been cited.
At 366, it is there on record. Yeah, page 366.
Just place that on the next day. That certain judgments governing the field, of recent origin, have been cited, which have in order to enable the appellant to come prepared on the said judgments, let the matter stand adjourned till November 24, 2025. Mr. Mukherjee, we are not putting anything on record, please.
Yes, my lord, I will.
Ensure that nothing is done in this short.
No, I will. I'm telling, and it's no demolition. It was only renovation work which is happening. My directors are living there on the 4th and the 5th floor. It's a resident ground, basement plus ground plus 5 floors.
So how did you put that on record?
Well, they had filed a criminal case against me. In that criminal case, I had filed a written objection.
That has been annexed by them.
Yes, they have annexed it. And even then, they're still making an allegation of demolition.
Yes, because photographs show that it's being
Sanction plan, I have put it on record.
They say that you
I
are
don't
lying
have.
there. You are not doing that.
You'll see what is on record. Even for demolition, I need a sanction plan. I need a plan for demolition. Yes. For demolition, also you need a plan.
Full demolition,
Yes,
you don't need a plan.
Yes, yes.
You need a plan.
Need a plan.
Not just go and demolish.
Yes.
Because
With a JCB.
There's a provision under Howrah in the Act.
And
no, it has to be a plan.
Yes, I have
Otherwise,
to inform and then demolish.
inform and probably some
I don't
sanction
need
is required.
sanction of a plan.
put it on.
Not a sanction plan,
I
but
don't
permission is
need-
required.
Yes.
You cannot burn,
required.
demolish a property
But he's
because
saying my
life and limb of the others will
No,
be.
no, absolutely.
Yes.
I need to inform, but I don't need to go and sanction a plan.
Not a plan. He's not saying a plan.
My lord, I have annexed the copy of the plan by which I'm doing renovation, it is annexed. I have annexed the copy of the letter given to the police that I'm carrying out renovation. All are annexed.
We'll go into that, and if necessary, that can be recorded. If that be so, then your injunction
No
is not
question.
necessary even. Yes.
And that is their only ground for injunction, that there's demolition.
You can record the submission on that. That will also help you.
No,
That is
you
the
have to-
scenario. Then
Yes.
no.
No, let's come back and argue this.
wants to see the.
No, if you can, if you agree to that,
I'll come back and argue the point. Come back. I've got the hint. That's absolutely correct because recent judgments.
I see there's a 10th November order. I have not seen it.
Mr. Banerjee, please ensure that two printouts are there underneath. That will help us also in other matters.
I wasn't aware of that judgment.
I personally speaking for myself, I was not aware of any of these three judgments.
Well, I was aware of that IS Sikandar.
No, those yes. Justice Datta's judgment.
Justice Doctor, I was not aware. Also, Justice Pardiwala's.
Sikandar also, you go through it. There may be certain.
Sikandar, I am ready to tackle, but it was only this.
Then the rest depends on your muqaddar. So next, yes. Thank you.
How obliged, my lord.
My lord's one-liners are better than him.
Oh, don't say this to me. Yes. This is very mischievous of you. But Mr. Mukherjee argued very well today, actually. Splendid arguments. You must say that to him. Yes.
This is the
Yes.
appeal.
Don't say this is we forgot what the matter is.
I was praying that a corrected appeal be listed along with the matter.
Oh, that. Oh, this is sorry. Yes. Learned counsel for the
There
for the appellant here.
pending.
For the appellant in both.
Learned counsel for the appellant submits that a connected appeal bearing FMAT 462 of 2025 along with CAN 01 of 2025 filed therein be listed along with the present appeal, comma, due to identity of the causes. Full stop next para. Accordingly, let the said appeal and the application be listed along with the present appeal, present application on November 24, 2025. That is the only day. Yes, which strategy is there? Yes.
There is
Yes.
another matter, my lord, which is connected with this, which is from your lordship's order. But the problem is, my lord, that matter, my lord, your lordship was sitting with Justice Kumar with the review, my lord, which will go back to the root of the matter. That also needs to be, my lord, heard because
We'll ensure that this matter is heard before we sit together. We won't any further complication, Mr. Chatterjee. We'll first let this matter.
24th, my lord, is on Monday.
Yes, madam.
Lord, we have served our application for addition of party. If my learned senior friend wants to use an affidavit to it, he can.
But,
do that.
so far as this application for addition of party, since Mr. Chatterjee's client is the plaintiff in the other matter, the one that I
will concede.
Yes.
We'll allow that on the next day.
Can be heard. So we taken on record that we have served the application upon them.
No orders today. You come back on that.
No, orders are very important, though.
No, we passed an order.
Yes.
Obliged, but not on this affidavit services. Next.
Lord, I was hearing the last matter, my lord. There's a difference later. There has been a difference to that judgment, probably a little later.
Oh.
There is, if I'm sure Mr.
Justice
Chowdhury-
Pardewala's judgment was cited by
Ah.
Mr. Banerjee saying that it differs.
Did he cite that? Then
Yes, yes, he did. Yes.
yes. But the problem is they don't send it to the larger bench.
No, we'll see if it has been, yes.
Because if there is a suit for specific performance, that itself is inbuilt. That the
Inbuilt, isn't it? Inbuilt, exactly.
inbuilt.
That is what we learned all along. It's
all
inbuilt.
along.
I want a specific performance of that contract and other.
It's inbuilt. Like a suit, like in a suit for specific performance, recovery of possession is also not required. It's inbuilt.
You must invite our judges in the Supreme Court someday for some occasion. The bar should invite and we should have a talk.
It is written by one of us.
That's why we should have an invitation and then. Yes, Mr. Thor, what is the matter?
I beg to represent the state.
Both of you are alter egos of the state, so it's a
Alter-
collusive matter.
I tell you, Lordship, my lord, what has happened. My lord, one person made a complaint, went before the National Green Tribunal, saying that this was a pond and water body is getting filled up and they are making constructions on that filled up water body. Though
they means who?
One of the complainants before the National Green Tribunal.
No, they said that you are making that construction.
Yes, against my client. Now, thereafter, after hearing, the Honorable National Green Tribunal has directed the concerned district magistrate to constitute a fact-finding committee. And fact-finding committee, after constitution of that fact-finding committee, went to the locale without giving any notice, without informing us, intimating us, filed an inspection report before the National Green Tribunal. And next date is fixed in June 2026.
That you are filling up a pond.
Yes.
What about?
Yes. And that particular report also says about the notice issued under Section 4C5 of the West Bengal Land Reforms Act. We have challenged those notices issued by the concerned block land and land reforms officer before the Land Reforms Tenancy Tribunal, because specified act, once it is issued, we had to go before the LRTT. And on the first date, we have prayed for stay of the operation of those notices, or in the meantime,
Notices means section 4 notice.
Section 4C5 for restoration. It has to be restored. That was not granted. Challenging that, I am before my lord. Now, my lord, I'll show from the act and the documents that it was filled up well before 1986. Why I say 1986? The 4C has come into the statute book with a retrospective effect of 1969, March 1986. That is the cutoff date.
If there is a retrospective effect, what is your take on that?
Yes, my lord, that is, my lord, I'll take your lordships to the.
You are very, courts are generally very sensitive on filling up of water bodies.
If there was no law by that time,
Retrospective effect takes
well,
care.
by that time, 77.
That is the meaning of retrospective effect.
Well, I'll take your lordships to the judgment as also the manual. Well, I'll kindly come to the deed through which I have purchased. It was purchased in the year in between 1977.
Give us the date of the deed.
The conveyance deed.
Yes, the deed
Yes,
which you're
1977.
Kind
One
leave
deed.
of my learned senior friend. My learned senior friend is before your lordship. Prayer for stay of 4C5 has been rejected, turned down by the learned tribunal. Here, my lord, from the report I have collected from the concerned jurisdictional authority, I find that they are not proceeding with the case as now. Here on record,
You will not proceed at
with
all.
this, not proceeding with the 4C5 because it's sub judice. It is clear from the report. So if that be so, my lord,
We'll hear the appeal, fix it on someday. We'll record this.
yeah, may I file this? Report?
Should we direct the tribunal, they dispose of the appeal and direct the
Lordship,
and we'll put this on record and on that basis.
Lordship, I'm also serving a copy to my learned senior friend also. Kindly seize page 2,
paragraph 6 of the report. I have handed over, Lordship, 2 copies. May I respectfully invite your Lordship, to page 2 of the report, clause 6. In the meantime, the BLNLRO Kongsho could not proceed further in this regard as the matter is sub judice before the Honorable NGT and before the Honorable LRTT. So this can be taken care of. He will not proceed with this.
We'll record that and dispose it,
Lordship. It's a report by the DLLRO.
Without going into the details of the matter, the present challenge has been preferred against the refusal to grant stay of operation of a notice issued under section 4C, 4 capital C within bracket 5 of the West Bengal Land Reforms Act 1955 issued to the appellants for restoration of a property on the ground that the appellants, the petitioners have been attempting to fill up a wetland, a water body. Full stop, next para. At the outset, learned senior government advocate hands over a bunch of documents, including a report authored by
the District Land and Land Reforms Officer, dated 18 November.
The District Land and Land Reforms Officer,
Paschim Bardhaman.
Paschim Bardhaman, dated, what is this, November 18th?
18th November 2020.
Dated November 18, 2025. In paragraph number 6, which had been, of which it has been stated that the BL and LRO Kaksha KANKSA could not proceed further with regard to the said notice under section 4C within bracket 5, as the matter is sub judice before different judicial forums and this court, including the WBLRTT. Full stop, next para. Since the present challenge itself is against an order whereby stay of operation of the self-same notices was refused, in view of the stand now taken by the DL and LRO, the prayer for stay becomes redundant, since the DL and LRO has undertaken not to proceed with the proceed in pursuance with the said impugned notices. For sub next para, accordingly, WPLRT number 180 of 2025 is disposed of in terms of the above observations, keeping on record the copy of the said report handed over by learned senior government advocate. It is expected that the original application pending before the WBLRTT, in connection with which the present writ petition has been preferred, shall be disposed of as expeditiously as possible, preferably within 6 months from the date of communication of this order to the said tribunal. Next para. In view of the undertaking of the DL and LRO, the respondent authorities, it is expected, shall abide by the same and not take any steps during pendency of the matter before the tribunal, but in pursuance of the impugned notices under section 4C within bracket 5 of the 1955 Act. No address to cost. Thank you. Much time saved.
Yes, lot of time saved.
This 7 learned advocate Usha Maiti is appearing. She is on leg in other court.
Not a
Suddenly,
good
I'm praying for short passover.
Not a good job.
This matter, my lord. She asked me to pray before just one country matter is called, my lord. That's why she went there.
So not in this matter, then why are you asking for time? What is the matter? We'll look into it.
Representation has directed to be considered by the learned tribunal. She is not happy with this order. Last 2 pages of your lordship's brief. Internal page 2, my lord. Last 3 paragraphs from board. We accordingly dispose of this matter, directing the BLLRO, Kharagpur, to dispose of the representation subject to suitability so and so, after extended opportunity hearing to both, taking note of the mandate of High Courts,
without Ms. Maiti's
High Court, Civil Court and all this.
What High Court Civil? Yes, why have you challenged this? She's not in the matter, she says.
Not sure. Not today, Lordship.
Not today. Great. In any event, I'll have to write soon. We'll have to write soon because I have a different benches. Great. Not today, কিছু order record করতে হবে না।
But I beg to appear on the petition.
Yes.
The Big Rath was my vendor.
Oh, sorry?
Big Rath was my vendor. I purchased in the
What about the other side? You have given a notice?
affidavit service.
Notice has been served, proper notice has been served?
Yes.
Received?
Yes, fine.
Have checked up? Yes.
But Big Rath was my vendor. I purchased in the year 1977. Thereafter, a vesting proceeding was initiated by the BLRO. It was an ex parte proceeding. Order of vesting was challenged in appeal. Appeal court set aside the order of vesting and directed the BLRO to open a new Khotian and to record the name of the purchaser. Thereafter, nothing was done for several years. 8 to 10 years, nothing was done. I filed a representation. My representation was not being considered. I approached the LRTT. LRTT directed that you muted the name in the as per the order of the appellate authority, appeal under section 54, the order that has been given by the district land and land reforms officer. I was initiated with a notice for hearing. That was redundant, not required, but still notice was issued. I appeared before the BLRO. BLRO passed an erroneous order saying that the file is not traceable, firstly. Secondly, some other proceedings are pending before the before tribunal.
There was a specific direction, you say?
Yes, there was a specific direction by the DLLRO to mute it after divesting.
You give another notice to the other side, we'll dispose of this matter.
My lord.
You are appearing for the respondent or asking for time?
My lord, Mr. Vivekananda Ghosh is appearing in front of like he's coming, my lord.
Let him come. We'll rise. But let him come. Affidavit of service filed today be kept on record. Due to paucity of time, the matter cannot be concluded today. Accordingly, let the matter be listed tomorrow for hearing. We'll dispose of the matter tomorrow. Go through the matter.
We have points of maintainability which will place.
Yes, maintainability placed tomorrow and we'll dispose of the petition tomorrow.
Yes.
Very short point.
Madam, I have prepared a supplementary affidavit annexing one order.
You have given a copy to them?
I have prepared.
Copy of the supplementary affidavit. Leave is granted to the petitioner to file a supplementary affidavit, which is kept on record. A copy thereof is handed over here and now to the learned counsel for the respondent. Come back tomorrow. We'll see, they have annexed only orders probably, but take instruction.
Yes.
Tomorrow.